actually the mediation. After a long time, we are going to have it in a physical. I think it's the first time we are going to have the physical mode of the training. Good morning, friends. As a self-introduction, I am a lawyer based out of Chennai, India, and also an arbitration practitioner. After getting connected with Mr. S.N. Goswami, sir, I have totally changed to be a mediator now. That is the effect of WIMS as well as Mr. S.N. Goswami, sir. Both, whether it is going to be arbitration or mediation, it might be new to certain people, it might be familiar to most of you. But as lawyers, what is our main task? When a client approaches, we have to find a good solution for them, subject to what fees we are going to get. That is more important. Fees is important. Don't do anything pro bono. But when you opt for this activity, that is the alternative dispute resolution, you have to do certain role in a pro bono basis. No doubt on it. At least to start with. Whether it is going to be a family dispute, whether it is going to be a property dispute, whether it is going to be a basic commercial transaction, whatever might be, you have to be ready to do the pro bono work to some extent. Having said that, what is all about ADR? And today my task, there are going to be multiple trainers. I am going to take this 4-1 session with 2 tasks given to me. One which is displayed, that is the Singapore Convention on Mediation, and another is going to be mediation in arbitration. This is just an introduction to all of you. You are going to hear an excellent presentation by multiple trainers from multiple countries having their own experience on the mediation component. In our region, we are always happy to visit Singapore. How many of you are ready to travel to Singapore? Just raise your hands. How many are happy to travel to Dubai? How many of you are happy to travel to London? Okay. Which place you are not interested to travel? Nothing. Okay, fine. There is no restriction for us to travel to any location. And obviously Singapore is considered to be the best destination to all of us. It is not only for leisure you can travel to Singapore, it is also good to travel when you are going to change yourself to an ADR practitioner. Singapore is considered to be the best destination for both arbitration and mediation. The only reason is that in arbitration they have a good institution, professionally managed, internationally recognized, which is called the Singapore International Arbitration Center. Similarly, when it comes to mediation, not to that the international standard, but reasonably the Asian standard, they have created an institution called Singapore International Mediation Institute, SIMI. And this was an excellent creation by all those practitioners in Singapore, including the government, by bringing in this convention, which is called United Nations Convention for International Settlement Agreements, UNISA. UNISA, Shanta is very happy because yes is there. UNISA is a convention which came into existence in 2018. This is just an initial slide which shows that what is all about the Singapore Convention and the signing ceremony. United Nations Convention on International Settlement Agreements resulting from mediation. This is the title of that particular convention. To a simplest language, we are addressing that to be Singapore Convention on Mediation. This convention was adopted by UN General Assembly on December 20th, 2018, and the signing ceremony happened on 7th August 2019. All these quite common for any treaty or convention, but the interesting thing is that on the day of signing, there were 46 countries who accepted and signed. That is very important. You can't see in the history of whatever you have learned or whatever you experienced when it comes to convention, the signature ceremony having so much of countries accepting and signing it. Bangladesh was not there, but India was there. India was there, and that decision was made within a week to sign it. They rushed to that particular signature, but this number is quite a phenomenal number, and based on that, this is the statistic presently we have, September 2020, there were 53 signatories to the convention which came into effect from 12 September 2020. This is just a basic initial component of this convention. In arbitration, you have heard many conventions. Can you recollect? I think many people would have gone through the Arbitration Act 2001 of yours, Bangladesh Arbitration Act. In that Bangladesh Arbitration Act, a very common convention would be mentioned that is called the New York Convention for Enforcement of Foreign Arbitral Awards. It was in 1958. That was considered to be the very prominent convention. As of today, more than 164 countries have signed and also ratified that particular convention. Very interesting. 164 countries is a big number. That means when you're going to arbitrate in Bangladesh, you can also enjoy the outcome to be enforced in all these convention countries, 163 or 164, whatever the numbers, because Bangladesh also is signatory. So much of harmonization happened in arbitration because of that convention, and similarly, this convention also has created a harmonization of the mediation law, mediation rules, mediation regulations in the signatory countries. That means we can mediate not only domestically, we can also mediate internationally or cross-border. That was a major objective of this convention. It had certain reservation that I'll just follow up in the subsequent slide. What is that convention is all about? A simple framework which is being given here. This convention, it's a framework for the enforcement and invocation of international settlement agreements resulting from mediation. It applies to international settlement agreements by mediation. It is to resolve any commercial dispute. It is to bring certainty and stability to the international framework of mediation. We are every day in the newspaper, if you are reading, we can see mediation, and presently you can see mediation to some extent successful today morning. In the Middle East, they have started the ceasefire for 4 days. This is out of mediation. This mediation, the international mediation, has to have a recognition. Otherwise, where is the backup? If you see the historically disputes, there are ethnical conflicts, there were commercial conflicts, there were cross-border conflicts, there were boundary conflicts. Initially, it won't be a significant one for us to understand, but we have to start from there. The macro, then come to the micro. The macro level disputes, the larger disputes between countries, between races, between communities, those mediations have to be addressed. During COVID time, many of us started to do online dispute resolution. We were not trained on it. We were used to have the traditional courts, going to the courts and argue before the judges. Now, after the COVID situation, we happened to sit in our home or office and we started arguing before the judges through online. But in our legislations, the procedural code, what you have, the civil procedure code, as well as the multiple legislation, the online mode was not recognized. But still, the policy makers gave us an opportunity to move to online. This online, even now, it's not properly recognized. But this convention, the day one itself, gives that opportunity to deal with community mediation, online mediation, commercial mediation, family mediation, every type of mediation, whatever is possible under the sun can be done. Do everything, take it everything to mediation. Don't go to the courts. I could see the quote here, some quotes here. Let us never negotiate out of fear, but let us never fear to negotiate. John F. Kennedy's version, LNF. But if you come to our region, Mahatma Gandhi has given a quote when he was practicing in South Africa for 20 years. He was very successful to mediate the disputes, and he also gained what he is entitled, that is the remuneration. Nothing he has lost. That was his version in his biography. All these is making our dispute resolution system simple. This particular convention gives us the meaning of the term alternative dispute resolution. Can I just get from you what actually you understand from the term ADR? Alternative. That is, as lawyers, you forget that you all are non-lawyers, or you are not lawyers. You just interpret this acronym to your way you like. What is ADR? Pardon?
Settle the dispute outside the court.
Okay, dispute settlement outside the court. Okay. Still you are a lawyer.
Negotiation, mediation, conciliation.
Negotiation, mediation, conciliation, all these categories we can just include. Still you are a lawyer.
Informal settlement.
Informal settlement, a smart way of saying that I am not a lawyer.
Try to fix settlement within two parties, giving two parties the same kind of benefit.
Okay. Indirectly she is trying to say, if you come to me, I'll make both the party win-win. But if you ask me, presume that even though I am a lawyer, now for another 5 minutes I am not a lawyer. If you ask me ADR, everyone would be happy to be healthy. Yes or no?
Yes.
In India they will say A for apple. Okay? Everyone, whether you like it or not, had to get married. Obviously. It's not a discrimination. Either way, it is like inviting devil. Apple, devil. What R is for? Anything presumption. You just enter into my shoe or brain, whatever, what I am thinking, what might be R.
Reduce.
Pardon?
Reduce.
Reduce?
Rule.
If I reduce my weight, I am gone. Apple, devil, R. What can be R? Pardon? Restore. Something different.
Raita.
Pardon?
Raita.
Right. Okay. Coming from South India, we always complete our meals with curd rice. Here I can't get the proper curd. I can get a raita. apple, devil, raita. Obviously, that can also be accepted. Similarly, if you ask an economic student or an economist, ADR means how they address. They'll simply say American Depository Receipts. I heard about it, ADR. In economic papers, whenever there is crash in the stock market, look into the yesterday's paper, it will be American Depository Receipts so and so. There will be crash. And economists look into the ADR like that. So much of convenience for this acronym, but as lawyers, the predominant one, we were looking into that to be alternative dispute resolution, but you have to change that perspective because of this convention. And that perspective is of 4 categories. Kindly note it down. 1, it is accepted dispute resolution. Accepted dispute resolution. That means the disputing parties are accepting it. They are giving the legal sanctity by accepting, giving the consent to go to mediation. Second, approved dispute resolution. Approved. A-P-P-R-O-V-E-D. Approved. It is approved because we do have legislations, rules and regulations. Obviously in your country it's going to come, but in most of the jurisdictions we already have it. It is going to be authenticated dispute resolution. That means it is not only facilitated having the legal sanctity, now it can also be enforced. The outcome can be enforced. And finally, it is also authorized dispute resolution. Authorized with this convention. If Bangladesh signs, I'm not sure, Bangladesh sign, they will sign, surely. Because China has been one of the signatories on the day 1, and they also enacted a mediation act. Qatar has created a mediation act. Iran has created a mediation act. Kingdom of Saudi Arabia also has created a mediation act. Recently, India also has created a mediation act, but it to be ratified, this convention. If you look on the jurisdictions, quite vulnerable, including India, having too much of diversified perspective of any disputes, they have accepted. That means this convention suits all. Now the authorization also is there. Accepted, approved, authenticated, authorized. Too much of A's, but it is good. This is helping. Now you cannot look into ADR as alternative. It has to be either of these 4. That is the reason why we have to equip ourselves to understand what actually mediation is all about, what skill you have to develop, what is the mediation process, and what the final outcome we are going to get, and how that outcome is going to be recognized under the judicial system. Here, this convention has taken another interesting component which is called NSJS, Non-State Justice System. That is our history. Our British colonial history is non-state justice system. Before these codes, the procedural codes, before these legislations, most of our country have the colonial base. The British legislations we used to follow. Even now the procedural code is before independence. All these were created for our society looking into our NSJS. NSJS is nothing but our traditional way of dispute resolutions, which is now considered to be against human rights. When you go to a village, when we try to resolve the disputes, the villagers won't come to the courts or the systems in the metropolitan cities or the district headquarters. They try to resolve the disputes in their own location, with their own people, and they will also accept and abide by it. They don't use the word enforcement, they'll say accept and abide. Acceptance saved them from outcasting from the society. That was the tradition. That tradition is called NSJS. The dispute resolution system, which is called like panchayats, like lok adalats, which happens in the, I think you have adalat, no? Yeah. Even now it's working. Those were coming under NSJS, but now internationally those systems are considered to be against human rights because it is not a proper justice delivery system. It has to be accepted, and this convention has tried to bring a recognition platform for those NSJS also. We have to wait and see how it is going to be affected. Okay. This convention has given three important components for the term mediation. One, they are saying impartiality. Another, they are saying confidentiality. And the third one, self-determination. If you look all these three, self-determination is vulnerable to lawyers. If we allow the parties to determine on their own, when it comes to dispute resolution, where is the role of a lawyer? Lawyer has no role, but still, lawyers are stakeholders of this mediation. How? The lawyers are the first entrants to sit as mediators. We might not be a good witness, but we might be a good judge. And that might also lead us to be a reasonably good mediator. As lawyers, can we be impartial in any process? As lawyers, in a mediation, can we be impartial? We have to be. We have to be. There is a precondition that we have to be impartial. And it doesn't stop there. We have to be neutral. We have to be independent. We also have to be unbiased. 4, including impartiality. When we take up the role of a mediator, this particular convention says that you can consider any person in this world to sit as a mediator until and unless he can understand the language and the culture of that particular disputing parties. That person has to be independent, that person has to be impartial, that person has to be neutral, that person has to be unbiased. That is a condition. That condition has been facilitated by mediation. If you sit as a mediator or anyone, one thing you have to keep in mind, the role of a mediator is not only confined with lawyers, it can also be done by any person. Any person who is a reasonable person of sound mind, that's all. That person can sit. You are going to have competitors in this profession, but we can succeed, no doubt on it. But still, there will be psychiatrists, there will be social workers, there will be even the domain experts, the subject domain, that's a technical person also can sit as mediators. Predominantly they will come, engineers, structural engineers, civil engineers for construction disputes. But still, this quality is being assured under the mediation in the Singapore Convention. No doubt, we can satisfy. Confidentiality. That process has to be confidential. How we are going to maintain this confidentiality? As lawyers, we have a special aspect which is called privileged communication. Whatever be correspondent between us and the client need not be disclosed to any third party. Even in a criminal issue, the police, the prosecution cannot question us and get the information from us, whatever being provided by our client. A privilege. That is unique. This is different. Here, the confidentiality is not a privilege. The confidentiality is within the stakeholders, wherein that confidentiality gives assurance for a successful outcome. Everyone, when they approach to the courts, and if the courts takes up the facilitation of the lawyers, that system and the process become adversarial. And it prolongs and ultimately reach to the apex court in any country. No doubt. And if one party happens to be a government or the government entities, invariably it goes to the apex court. Whatever process it starts, from the scratch to the final destination. How many years? Minimum 20 years. A common tradition in our region. But the parties can't get the outcome. Even if they get the final outcome, which is enforceable, that process makes that particular happenings in public. Our case might be reported in the journal. Our case might be reported in the media. Our case might be discussed by our neighbors, the worst enemy. And ultimately, we feel that we end up in a bad situation in the society because others would look us as a litigant. No one would like to have friendship with litigants. If you go outside, as lawyers, we are accepting, we are used to it. But if you ask our family members how to live with a lawyer, terrible person. Because we create an issue not intentionally, but for our client, we make that to be adversarial. But we have to be successful, for that we will do it. Nothing wrong in it as a professional. But still, for others, it can't be accepted. And if it's an adversarial and the process is non-confidential, it becomes public. There is a question of first maintaining the relationship between the disputants. Second, how we are going to be surviving in this society or community, whatever might be. Within lawyers we can survive, but clients, it's very hard. If you have a company and their commercial disputes is being taken to the courts and it is being published, the market would see that those persons, okay, why to have a contract with those persons? They always end up in courts. That notion might come. It's not that always it will come, might come. For that, we can opt a system which is also called confidentiality. It is not that totally it is confidential. The proceedings is confidential. The Singapore Convention says that the proceeding has to be kept confidential until and unless it reaches to the courts or any system where it is likely to be enforced. When it comes to enforcement, it is public. Until that time, we call this component to be private and confidential. That is also assured under this mediation convention. These three are considered to be pillars of this convention, which also makes multiple countries to accept this convention, and now the numbers are increasing. It might cross 100 within a year or two. What are the other objectives of this convention as a theory we have to take into consideration? It has to ensure binding nature and enforceability of international mediated settlement agreement. It is not speaking about domestic. Keep in mind, like arbitration the Act of your country 2001, which is basis on the UNCITRAL model law for international commercial arbitration 1985. Here also, this is for international mediated settlement agreement. We can try to adopt it for domestic also. Facilitation of international trade, one of the main objective. Then promotion of mediation as an alternative. They didn't stop there. That is interesting. And effective method. That is all the other 4 E's. Effective method of resolving trade disputes. They want to have a harmonious trade system to bring certainty and stability to the international framework on mediation, greater certainty in resolving cross-border disputes through mediation. Many of you would have seen there was a dispute between the Emir of Qatar and the entire GCC countries. Can you remember? Before even COVID situation. You can't just fly to Dubai and then to Qatar. Iran and Qatar were isolated. Trade embargoes were levied on these countries, specifically for 4 to 5 years. It is purely they wanted to just suppress these countries for the benefit what they got in international trade. When they tried to solve that issue, mediation was successful, and in those, the Singapore Convention learned a lot, and they wanted to bring mediation for facilitation of international trade. We can't just survive for long stopping the imports. We import oil, we import commodity, we import metals. If you are not having those for 1 week, what will happen? Gone. We can't survive. Here, if you are going to the courts, if these disputes, international trade disputes goes to the court, where can end up? Which court? It is not we individual can represent and file. It has to be through the government. The entire system gets collapsed. No people can survive without this. Everything now, the option is only mediation. Don't end up in ICJ. If you end up in ICJ, it takes several years. And ultimately, even after getting the outcome, to what extent we can enforce it? It's very hard to enforce it. Without an enforcement mechanism, any regulations, any treatise, any convention doesn't have a value. This convention has given that it can also be enforced. An outcome of a mediation can be enforced if those countries are ratifying this particular convention. Which are the countries as of now which we got from the list, official list? Have a look on these countries list. Afghanistan, if you look on this map, most of the Asian countries have accepted it. Afghanistan, Armenia, Australia. Look into these 3 countries. Which is the common disputes you can see in these first 3 countries? Afghanistan, now the rule of law is questionable. Whether it is enforceable or not, we are not sure. Armenia, you might see Armenia-Azerbaijan border dispute. So often Azerbaijan missiles end up in Nagorno-Karabakh region. Australia, suborigines, the local indigenous people are being suppressed by the government. See, the 4th country. In Belarus, we have a mediation act also. Then other countries like Belarus, Brazil, Brunei, Chad, so many countries. If you look on all these countries, including you can see China. China is quite dominating in the diplomacy because of the BRI, Belt Road Initiative. And all these countries, when you look on, it is very interesting that Singapore was very successful to bring in all these countries because these countries are already facing a lot of cross-border issues, lot of trade issues. If you take Philippines, they are having a big problem with South China Sea. When you take Turkey, always vulnerable. At any point it can what you can say, to blast the country because of the northern region, Kurdistan. Ukraine is facing invasion. Every region is all vulnerable. You can't see USA ultimately they join. You can't see most of the European countries here. Can you see European countries? You can see Israel. They don't accept any international law. They make it flexible for them. All these countries are now within the ambit of the Singapore Convention, and this is the greatest success. Now, at least when we are going to deal with these countries, particularly whether it's a trade disputes or a commercial disputes or any disputes, it is so comfortable for us because there will be a mediation act in those jurisdictions. When you are going to deal with them, you can straight away take the dispute resolution to mediation. That means we need not know their procedural codes, we need not adopt their basic constitutional provisions, we can just go into the mediation and resolve our disputes. So convenient. Trade. Interact with them. Do all transactions with all these countries. That is what they wanted to facilitate out of this convention. Okay. This picture shows that these are some countries which have ratified that convention, Singapore Convention. It's all available in their website also. We can look into the Singapore Convention on Mediation website. The convention which came into force on 12th September 2020 in accordance with so-and-so article shall enter into force 6 months after deposit of the third instrument of ratification, acceptance and as well as approval or accession. Belarus, Ecuador, Fiji, Georgia, Honduras, Japan, Kazakhstan, Qatar, Saudi Arabia, Singapore, Turkey, Uruguay. Most of the continent. I am not sure to what extent Bangladesh has a trade relationship with these. What is very common in these countries? This is okay, fine. The best country in the world where you can travel, safest country in the world. And they are also invited globally. Singapore, obviously a premium country, which has initiated this convention. But if you see a country like Kazakhstan in Central Asia, it's quite big country, but full of a lot of deserts, but also with minerals, resources. Everyone is rushing to Kazakhstan to take the oil, explore the oil, do all type of trades. And the BRI initiative, Kazakhstan also is there because they share the borders with China. As a trade is the most welcome one. Qatar, most flourishing country. If you want gas, we have to depend on this country. No other country supplies so much of gas globally. Everyone is interested. If you go to Belarus, just Google and find. So much of water bodies are there. So fertile country, all of natural resources. Their political agenda might be different, but we are not worried about it. But as a trade perspective, it's an abundant country to do a business. If you go to a country like Uruguay, most happiest country in the world, South American country. Only the language Spanish. If we go to Saudi Arabia has recently changed their procedural code. Have a research on it. Greatest opportunity is there for all the countries in our region to deal with Saudi Arabia. They have changed. They are now modern, open society. They might be monarchy, but still their rule of law has changed. They are opening. They have all type of commercial laws accepting the international conventions. Excellent change. Greatest change we have seen, and that the mediation straight away is being facilitated by institutional mediation. This is one country which is accepting institutional mediation beginning itself, and another country is China. China also recognizes institutional either arbitration or mediation. They won't accept ad hoc. We are used to ad hoc. Bangladesh or India is used to ad hoc. We always, when it comes to marriage, we will accept arranged marriage. Always, rare change. But when it comes to dispute resolution, we will go to the flexible one. We want to fix on our own, self-determination. We will allow the parties to choose. We will allow the parties to agree upon whichever is not institutional. Ad hoc basis. Ad hoc is convenient because in ad hoc, we think that we can choose the mediator, we can choose the cost, we can choose the procedure, we can also choose where to conduct the mediation or arbitration, whatever might be. The choice is with the parties. When we entrust this mediation to institution, obviously those institutions will fix, they have a fixed cost, we have to entrust, register the case, they will take care. No doubt I am not going against the mediation center of the Supreme Court or the High Court. They have a structure, that's a different structure, that we call it as statutory or court annexed mediation process. But the actual mediation, the private mediation, predominantly happens in ad hoc manner, but this country is an exception. There is an institution called Saudi Center for Commercial Arbitration, SCCA, which exclusively administer mediation for any party coming out of Saudi Arabia or who are interested to deal with Saudi Arabian companies or individuals. We have to only register the case in that institution. In that way, they are also being regulated. That's very important. If there is a regulator and if there is a regulation to control an institution, particularly managing that process, no doubt we can presume that we will have the aspect like impartiality. Assurance is there. In ad hoc, how many of the cases you can say that it is impartial? We are not happy with the outcome of the arbitration award. We are challenging. Why? We are saying that the arbitrator was partial. Same way, mediator also might become partial if it is ad hoc. If it is institutional, the institution monitors that mediator, and if that mediator is going beyond the task what is being given, then he will be removed from the roster of the mediators or the panel of mediators what they are maintaining. There is accountability levied on that mediators if it is an institutional mediation, and the Singapore Convention is being adopted by these countries wherein most of these countries facilitate the institutional mediation. That is very important. It is not only mediation, institutional mediation. Okay. Applicability of this convention. How it is applicable? The effect of Singapore Convention is that where a party to a qualifying mediated settlement agreement fails to meet its obligation, said settlement agreement can be directly enforced in the national, that's very important, directly enforced in the national courts of any signatory state rather than need to restart litigation or arbitration proceedings. This convention is therefore analogous to the New York Convention on recognition and enforcement of foreign arbitral awards for arbitral awards, whether it is domestic in one country or it's foreign, depending upon the seat of the arbitration. This is what you can say a combo. New York Convention was dealing only with enforcement of the award, and before that unsettled model laws for arbitration. But the Singapore Convention is for both. It gives a structure for mediation process as well as enforcement. Very important. It's a combination of all. This combination makes comfortable for everyone to adopt. A country if has been adopting, and if you are going to have a mediation, anyway, I think in your Civil Procedure Code, section 89A, capital A, you have a provision wherein that provision permits the judicial officer to refer the matter to mediation, conciliation, arbitration, or any other dispute ADR mechanisms. Yeah. Here, this convention, if it's been ratified by a particular country, then we are going to have a wholesome legislation and we have no option to go to the courts. Because the outcome, the mediated settlement agreement, directly enforceable in national courts. We have that recognition. We need not go to the courts and get it ratified, approved, registered. No formalities. Take it to the court to enforce. Because enforcement cannot be done by an individual. An individual cannot do it. If an individual is trying to enforce, then the society is collapsed. It should not happen. That enforcement alone, national courts are there to deal with it. It takes its own time, but we have to wait for that. The process from initiation till getting a successful mediated settlement agreement will be done within a reasonable time. Reasonable time, it can be even a day, or maximum of 6 months. If a dispute trial period is being shortened to so much of shorter period, we are also better remunerated. Lawyers are also permitted in the mediation process. There is no restriction. We are not excluded. We can participate on behalf of the parties. We can sit as mediator and don't be a party in a mediation. What are the other key features? I'll just quickly brush up in this convention. It promotes credibility in resolving of cross-border disputes. You saw. What is the content in it? The parties can directly enforce a mediated settlement agreement and place such settlements at par with the arbitral award. There is another provision in the Arbitration Act 2001 of Bangladesh, which starts with the term, I couldn't recollect the number, the section.
45.
45, thank you. It starts with the word, it is not incompatible for the arbitral tribunal to try mediation or conciliation in arbitration. That is my next session, I'll anyway cover it. Similarly, here a mediated settlement agreement is at par with the arbitral award or judgment, thereby providing mediation to be a credible source for resolution of commercial disputes internationally. Not only domestic, internationally also. Next, facilitation of international trade helps in growth of regions where parties of the convention belong. Obviously, the society would be peaceful because now we are all depending upon economic. Commercial is controlling the entire world. Uniform framework, building of harmonious economic relations regardless of the differences in the social, economic as well as legal system in their domestic countries, the host countries. These are some events which you can go and further enrich your knowledge about the Singapore Convention. It's already done. Regularly they do conduct. 2023 they did. 2024 they are planning to have all these. Yeah. This is the scope of this particular convention. As lawyers, always we need to understand section 1 of any act. Likewise, this convention Article 1. The convention will cover the subject matter which is earlier mediated and the settlement agreement has arisen from the mediation process. The dispute or the subject matter should be international and should entail to cross-border dispute. Subject matter should be commercial. In arbitration also you can see this. We always say, normally as an arbitrator, we try to say commercial arbitration or international commercial arbitration. Same way here. Subject matter should be commercial. The working group assented that the broadest interpretation should be adopted. And specific exclusion, this is where the key element is that no mediated settlement can be enforced against government. That is a reservation what has been taken by Iran, taken by Belarus, taken by Qatar. Subsection 2 and 3 of Article 1 excluded personal, family and household issues. They are not recommending. In international, under the international disputes, they are trying to avoid, but in our domestic we can bring it, which are enforceable as judgments or arbitral award are also excluded. This is an exception, but most of the government has taken the part of the government or the government involved to be exempted from any enforcement against them. Yeah. Here, anyway, the slide is shared. Organizers can share with the participants. Another 2 minutes, I'll stop the session. Just look into this point, lawyers heaven. We have the opportunity not only in the mediation process, post. If that settlement agreement, similar to your setting aside process in arbitration, we have this. If a party to the settlement agreement was under some incapacity, a minor, an unsound person, an unauthorized person, a company which is not properly incorporated, if they are parties to mediation and the outcome, a settlement is arrived, normally there will be a lot of nexus, collusion, process itself. Those cannot be enforced, that can be refused to. We can challenge a mediated settlement agreement also if the settlement agreement was under some incapacity. Second, if the settlement agreement is not binding, null and void, inoperative or incapable of being performed. Something which is impossible has been agreed in the settlement agreement. It is not that it has to be enforced. It can also be challenged. If there was a serious breach by the mediator of standards applicable to the mediator, without which breach that party would not have entered into the settlement agreement. It is a very professional word is being used. A mediator also might be subject to unwanted practice. If out of those unwanted practice an outcome is there, that can also be challenged. If granting relief would be contrary to the public policy of that party or the country, those parties. It is like, there is a component called a horse, an animal horse is there. If the horse is permitted to just move around, what would be its destination? Like a school boy going to a college, to a hostel. They'll roam 360 degrees. Horse also roams. Only I am mentioning boys, not girls. 360 degrees. And that is a wonderful place you have to visit in South India. Near the Cape Comorin, Kanyakumari, there is a place called Tiruchendur. There is a Hindu temple. To go to the temple, we have to get down in a railway station or a bus station. There will be a horse. They call it a horse, but it's like an ass. We have to get down And when you get down and you take that, they call it a horse vehicle locally in that place, and you sit, even without the person, the rider, it straight away, it goes straight, right, left, right, it reaches the temple gate. Perfect. It doesn't go 360 degrees because it has that. A public policy is like a wild horse, like Genghis Khan. If you see in Mongolia, the horses grazing, it roams anywhere. Not like our domestic cows or cats or like even a camel in the Middle East. They just go like this, saying whatever the master says. But the horse is not so easy. A public policy is like that. It keeps on changing. It based on our judicial precedents. Whatever judgments is being given, it changes. The policy changes. But we have to be cautious in a mediation process. If a settlement agreement is arrived and that too is against the public policy, then it will be set aside. It can be challenged. That also is being recognized under Article 5 of the Convention. Okay, these are some narration for you to later look into. Enforcement. Thank you. Thank you friends for patiently hearing the first session. Now I have to break for once again welcome. This is a combo what I am going to share for another 90 minutes. Anyway, I'll try to stop by 12:30. Two ADR mechanism, whether it is possible in one process. Can we mediate in arbitration? Can we arbitrate in mediation? Anyway, there is no scope for litigation here. You keep apart litigation. The entire 40 hours training is going to pull you only to mediation. But this combo is working really well in our region. Try either of these or try both in the same dispute. First, I will try to take all of you through med-R, mediation and arbitration, or first mediation, next arbitration. We have been trained, or we facilitate the disputants to enter into contracts or agreements. Whether it is a normal commercial agreement or it's a quite complex construction or a maritime agreement, we have always certain standards. And the common law system says that we need to have all these covenants, the terms and conditions, starting from the scope till final point to be the dispute resolution clause or the insurance clause. All these are common clauses. In an agreement or a contract or even an MOU, we have multiple terms and conditions, and one term, predominantly what we recommend is the jurisdictional clause. The clause which mentions that if a dispute arises out of this agreement or a contract, it will be referred to the courts in Dhaka. The traditional way our seniors would help us. We are used to mention the codes, or make it even simple. When you go to a supermarket, we are purchasing a set of cosmetics. They'll just give an invoice. I'm not sure about the back here, but the back of the invoice, there will be a lot of small words. 1, 2, 3, 4, 5, sometimes it even goes to 50. In that, there will be a jurisdictional clause saying that the courts in Dhaka has a jurisdiction. If there is a clause or not, and if a dispute arises, where we have to take it? If the clause is there, specifically mentioning, then we have to go to the courts in Dhaka, starting from the court of first instance, that is the subordinate court, to the highest court. If it is in a different city like Chittagong, then it might be in that jurisdiction if they would have agreed. Assuming that they are not mentioning, out of mistake they would have missed it, or the common thing, cut, copy, paste contracts, 1, 2, 3, 4 contracts, we will miss it out. If you are going to miss, and your transaction is happening in Dhaka, which court we can or we are eligible to approach? It is Dhaka. Obviously, the jurisdiction creates out of the transaction where it happened or where the parties are residing. Based on that, the maintainability would be answered by the courts or the registry while accepting the case. This is a very traditional practice, and to even determine the jurisdiction, it takes months. If it ends up in the courts for maintainability, it takes surely months. Instead of these, having court jurisdiction clause, we have a normal dispute resolution clause with ADR mentioned. Whether we need to enter into the courts? Yes or no? Alternative to this jurisdictional clause, a dispute resolution clause highlighting or mentioning the dispute to be referred to either of these ADR mechanism is that whether we need to go to the courts or we cannot go to the courts.
It is what that mentioned in the arbitration clause.
Yeah, I'll come to that.
If there is arbitration.
We have to be in the primary school, high school, then higher secondary. Thanks for it. As a party, we have always a right to enter into the courts. Thanks for it. It is not that cannot, may not.
It's a right.
Our colony people in the law says that may, shall, could, would. Oh, horrible. May not. But it is not that I cannot, as a litigant, I cannot. You can't say I cannot enter into the courts. There is no restriction. It is our constitutional right. Even though I have agreed on a dispute resolution clause mentioning it to be referred to alternative dispute resolution. Assuming that, taking the stands of all the lawyers and getting consent from all, we are advising the client, hey, you go to the courts. Even though there is a ADR clause or dispute resolution clause referring to ADR. A case, a civil suit is filed. You call it OS or CS here? Civil suit. CS. In India is peculiar. They also use OS because we have original site jurisdictions in some high courts. A suit is filed. In the contract, two parties are there. Minimum two, the two is there. It's not multi-party contract. After a certain time in the courts, the other party would, after sleeping long, like in Ramayana, Kumbhakarna, have you heard about Kumbhakarna? He sleeps for 6 months. After 6 months, the other party smartly goes, how this court has a jurisdiction, how the court can continue. Then all of a sudden they'll just put an application after 6 months, not after 6 weeks or after 6 days. We have agreed for the dispute to be referred to arbitration or mediation. Such a stand they will make, and for that there is also a provision in the Arbitration Act 2001 in the Bangladesh legislation. once such an application is being filed, what the judge would do? Any judges are sitting here or former judges? Okay, happy. What a judge would do? Huh? Louder, I can't hear.
Send it to the arbitration again.
If we have such a kind-hearted ma'am as a judge, send it to arbitration after 6 months. But actually what is happening, if a person, the other party is putting forward in the courts that there is a ADR clause, a dispute resolution clause with ADR, it is not immediately the court is going to refer. The court will scrutinize whether that clause is a valid clause or not. Unfortunately. They need not. Looking into your provisions, power of the court to refer parties to arbitration. That is the title of that provision. It's an unsettled model law provision. Nothing new. It's common in more than 100 countries. The only thing what has been given before the other party files is written statement, first statement. That is a written statement or a reply or a counter statement in the civil suit. It has to be raised. If it is raised after, then it becomes a discretion of the judge to refer or not. As a judge, now looking into the docket explosions in the courts, what they will do? Take another 6 months, 1 year is gone, they will say, refer it to ADR. This is with the clause. I am saying it is not, I am saying without clause. I will come to that without clause. The clause is there, still the parties out of ignorance or intentional, we are not sure, they are rushing to the courts. They rush to the courts to get interim relief. If you go to the courts, interim injunctions is quite quick for us to get it, subject to the capabilities of those lawyers and the jurisdiction where they are approaching. When you get an attachment before judgment, an injunction, interim injunction, then you'll okay, relaxed. The relief is there. Until and unless revocation is taken up, fine, we'll enjoy the outcome, sorry. Here, the court's responsibility is to look into the contract and refer the matter to ADR, whatever is there. Because the parties' intention, the parties have self-determined that they can or they shall or they will resolve the dispute through ADR mechanisms. Here, while entering into such a dispute resolution clause, now the latest trend, what the West has educated us, is that why to straight away go to arbitration, go first mediation. I'll make it even simple. Just now I had an interaction with a senior colleague. From which state I come? I come from a state called Tamil Nadu in India. It's very popular for medical tourism. The flight I could see, I was the odd man. When I was having my first international travel to Mauritius, there also I was the odd man. That was different. I was married a man for 5 years. Others were all young couple honeymoon packages. There was only the odd man seeing all those people. Here, I was similarly an odd man, fortunately, not with ill health. Everyone were traveling after having a good treatment from Chennai, and he was mentioning about CMC, which is near to Chennai, not actually near, it is more than 150 or 180 kilometers from Chennai, Vellore, CMC, Vellore. They had gone for treatment. Assuming that a person is not doing well, what would be the first step that person would take? If I am ill, I will take my own example, I am not taking any chance. If I am ill, first where I have to go? To the hospital. In the hospital, who will be the first person I will meet? Doctor. Normally you can say general physician. Once that person diagnosed, putting into all the list, 1 to 20 tests, take it and get back. That will take 1 week. Fortunately not MRI scan. I am getting back after 1 week. After 1 week, I will go to the same general physician. What would be the next step? He will guide me. He will refer me to a specialist. I am going to the specialist. The specialist gives options. A surgery or a medication for a longer period. Now comes the problem. Like before coming to us, the client would try 3 to 4 lawyers and finally to me. Similarly, then I just find so super speciality in that. And after reaching them, the third step, I will take the final call and I will go with either medication or surgery, depending upon that person's recommendation. This is a normal step when we are feeling ill. Assuming that straight away, when I feel ill, I am going to see the surgeon, what will happen? Instead of going to a general physician, if I am going to a surgeon, what do you do? Yes, come, tomorrow morning surgery, the package 5 days, 5 lakh Indian rupee, and you will be, on the third day you will be happy, you can go walking, and after that monthly reviews. Straight away, nothing wrong, because he is specialized on those surgeries. He won't say that you go for medication, you do like this. The same thing you think over when it comes to disputes. Don't ever rush to the final call. At least in the alternative dispute, the final call is considered to be arbitration. Don't go straight into arbitration, because now arbitrations, even though it has all the quality, it is considered to be twofold. One, it is like a quasi-judicial process, and another, it is very expensive process. No doubt, I am available for arbitral appointment, you can consider me. The cost and the quasi-judicial, because sometimes it also gets delayed. Similar to the course it's happening, don't rush to that final destination, try the first one. The first one is considered to be mediation. This is a solution, what we can find out looking into all these cases and how it has been resolved. But instead of this, can we have a combination, both? If we like to have both, that also is possible in this dispute resolution clause. That is called MED-R. We can have mediation and then we can have arbitration in the same clause. Very important. It's not that separate clauses, same clause. Traditionally, in Bangladesh and in South Asia, instead of using the word mediation, we'll use conciliation. Labor conciliations. Nothing wrong in it. It is both synonym only. Due to too much of Western influence, we are using now mediation and conciliation. The word is likely to go away in India. The new Mediation Act of 2023 clearly mentions it is replacing the conciliation provision in the Act. This is going to be history in India. We used to have conciliation arbitration clauses. I happen to see earlier clauses in your many of your maritime agreements, charter party agreements in Bangladesh. MED-R or conciliation clause is well acceptable clause, and that combination works out really well. Try that. We have to explore that, and to explore that, first, as an understanding to all, being a training program, I have to do some exercise for you. Take 5 minutes, everyone take 5 minutes. First draft a normal mediation clause. Sorry, arbitration clause first. All of you have paper? Yeah, pen? Fine. Sorry, we have to go to the college classes now. I'll give you 5 tips, 5 points for you to draft your arbitration clause. If you are not comfortable, you can use certain dislocations also, at least to write. 5 aspects to draft the dispute resolution clause leading to arbitration first. First one, nature of disputes. Nature, N-A-T-U-R. Nature or categories of dispute, whatever you can do. Nature or categories of dispute. Second, number of arbitrators. Number of arbitrators. Number of arbitrators. Third, applicable procedural law. Applicable procedural law or institutional rules. Applicable procedural law or institutional rules. Fourth one, place of arbitration. Place, P-L-A-C. Don't use the word venue, always try to use place or seat. Place, P-L-A-C, place, where, like this, where, Dhaka or Chittagong or any other cities. Place of arbitration. And the final point, language of the arbitration proceedings. Language of the arbitration. These are the 5 bullet points for you to keep in mind while drafting that paragraph. Make it a small paragraph with 7 or 8 lines, that is sufficient. Don't think about the contract as a large, just I am expecting the arbitration clause alone in that contract. You can also Google, many people have started Googling now itself. But Google until would go for 15 lines. We can confine it 7 or 8 lines. As a paragraph, make it as a simple paragraph. And there is a disclaimer, no fees would be given for drafting this clause. Normally senior lawyers charge 1 lakh for drafting such a clause. Nature of disputes, number of arbitrators, procedural law or the applicable procedural law or institutional rules, place of arbitration, as well as the language of the arbitration proceedings. Second one. Third one. Fourth one. 5. 6.
I'm confused with the place and language.
Pardon?
I'm confused with
Confused with the place and language.
Not confused, like what would be rarity.
Okay. You can just have some presumptions. It's just a hypothetical situation.
Can it be determined by the parties of the contract?
Pardon?
Can it be determined by the parties of the
Yes,
contract?
yes. One more minute. now I'd like to hear from one volunteer who wants to share what he or she has prepared. Yes. First time he has requested.
In this rental agreement, as we agreed to avoid the court proceedings, especially the Rental Tenancy Act 1991 to the possible extent, if any dispute arises regarding increasing of rent or common facilities, referred to the law chamber, we shall resolve the matter through arbitration. There shall be one arbitrator where the procedure shall be governed by the Arbitration Act 2001 of Bangladesh, and the proceedings shall sit in Dhaka, and the language shall be English only.
Okay, fine. A big cheer to him.
Yes.
I'm not sure about your tenancy law. There is one concept before, while we are suggesting drafting a arbitration clause. Not all disputes can be referred to arbitration, and the principle arbitrability and non-arbitrability shall apply. When we are going to have a special statute which is considered to be both substantive and procedural, then in that particular statute there will be a forum given where to approach and resolve the dispute. Very important to all of us to understand. This gives a major advantage why this. If your tenancy law, I think that's a combination of substantive and procedural. If it gives a pathway to this forum alone you can approach, then even if in the arbitration, even in the contract, if you have an arbitration clause, you cannot arbitrate. There is a restriction, non-arbitrable principle. A criminal act, some labor issues, tax issues, we cannot arbitrate. Non-arbitrable dispute. That we have to keep in mind. Fine. Great example. Assuming that tenancy is also arbitrable in this country, taking this clause perfect, he was happy to bring all disputes to arbitration. Fine. That was the nature. What he wanted to bring, all the disputes. He was not confined with certain disputes or specific disputes. Because at the time of contract, no dispute, future it might arise. Second, he wanted how many arbitrators? One. After a dispute comes, he wanted two. He wanted three. Okay, fine. With one, how that one would be appointed? Mutually. Just now I appreciated a person. If you are going to facilitate the two persons to come to a common ground and appoint one arbitrator, then there is no dispute at all. Instead of appointing a third person, straight away they can negotiate and resolve the issue. If they could agree for the third person, they could agree to resolve as a first chance. It's the rarest thing to happen in this commercial world for two disputing parties to agree a person who is going to be an arbitrator. Ultimately, after a certain time, the first party has to go to the court to get the appointment, the default appointment under appointment of arbitrators provision in your act. You know how long, who would be appointed as arbitrators by the respective courts. You can't just wait for a longer time. Fine. There is no restriction to have one, but there is a restriction to have two. We need to have simple majority, but if you are going to have three with a wider lens, the first two can be easily appointed. When you appoint the third one, there is a presiding arbitrator, or
chairman or an umpire. In India, we remove the word umpire or referee. In Bangladesh, I think you have chair. The chair without veto power. To appoint a chair also, it's a problem. We have to end up going to the courts. A settlement agreement can be derived, comma, or if it is unsuccessful, the parties shall go to arbitration, full stop. Then this line comes. The same paragraph, if we include 2 or 3 sentences saying that the matter shall be referred to mediation with a time frame, that is very important. What happens when we are contracting with Chinese parties? If you see Chinese contract, invariably conciliation, mediation, negotiation would be there. It will be a purchase order, 1 page, front and back print. Second page, they mention like a contract, they will say, if a dispute arises, the parties shall negotiate and settle it, full stop. Then they will have arbitration clause, arbitration under CTAC, China International Economic and Trade Arbitration Commission in Beijing. You have to go to Beijing to arbitrate, not in Dhaka, not in Singapore, not in even the southern part of China. You have to go to Beijing, headquarters. And that institutional arbitrations alone are recognized. Here, in those clauses, it is good. No doubt it is good. But the problem is, there is no time frame given. When to conclude the negotiation or mediation. If there is no time frame, what we lawyers would do? Endless. 2 years we will be negotiating, mediating or whatever. A time is very essential. And that time is given under the Singapore Convention also. And if your country is going to adopt your Mediation Act, they will bring a time frame. Whether you are going to mention it or not, no need to worry at that point of time. Because the law is there giving a time. In India, it's something different. To mediate, the time is 120 days. To arbitrate, the time is 365 days. 12 months, you have to complete the arbitration. But in mediation, time would be given under the convention. No need to worry if the law is going to be there. If the time is not mentioned in the law, it is very much essential to mention time. You can even give 1 day, or even you can give 1 year, nothing wrong in it. Give a time. End date should be there. If you are going to have a combination of mediation and arbitration in your contract, then you are more comfortable. Because not all disputes can be successfully mediated. Because in mediation, there are 2 components. One is called facilitative, another is called evaluative. If it is evaluative, it is our traditional conciliation. Mostly in our traditional conciliation, the conciliator prepares that settlement agreement. Some technical points, what I took it from the Russell on arbitration, very treatise which is considered. The parties agree in advance to present their case to a mediator, and should that process not result in a final settlement, the case will be submitted to binding arbitration. It is pure state that the same neutral is selected to serve as both mediator and arbitrator. This is quite earlier, before 1900s. As an alternative, a separate neutral can be selected to serve as arbitrator should the matter not fully resolve at mediation. This is quite confusing, no? In its pure state, in its purity, the same neutral, the person who has acted first as mediator, is selected to serve as both mediator as well as arbitrator. But don't try it. That is purity. We can't rely on this purity. 100% I'm sure a person who sits as mediator, if he is once again going to sit as an arbitrator, would do justice. He can't. Because in mediation process, there might be high possibility when it comes to private meetings, private caucuses, to come out with certain pros and cons of the respective parties, and that leads the arbitrator's predetermination. An arbitrator should not have predetermination. An arbitrator, after looking into the documents, after hearing the parties, then only he has to decide. He shouldn't be predetermined. That is the reason why the same person, it is mentioned the purity. In a purity state, fine. If I am sitting as a mediator and the mediator is unsuccessful, I can also consider to act as a arbitrator. This is called double hatting. Don't try double hatting. You can't take two hats. It won't be so available for us to, at least from our region, avoid it. Don't ever try it. That now the development is that as an alternative, a separate neutral can be selected to serve as arbitrator should the matter not fully resolved at mediation. If your mediation is unsuccessful, then you have to start arbitration. In arbitration, don't consider the same person to sit as arbitrator. That MEDAR would be a success. First, you can go to MEDAR. Second, to go to MEDAR, we have to have a predetermination to what extent it will be successful. To be successful, you have to be very clear, don't have the same person or don't have a person taking two roles. MEDAR, what in my personal experience, what I saw, normally the parties agree on the terms of the process, no doubt. They try to negotiate the issue through mediation and the mediator suggests possible outcome. That's all. Look into this picture. What you can understand here?
Both party win-win.
Both party
Win-win.
win-win. Both party agrees. See the face of these two persons. See these. See these. Everything matters.
They're happy,
Huh?
they're amicable.
They are happy. I could see only this man is happy. This picture, this my research team has done it. But this man seems to be happy. Not these two. And there is some paper kept. See, this lady has some coffee. This person, Starbucks.
Yeah.
With due respect, when I was in Palestine last year, I could see a shop called, similar to Starbucks, it was Snackbucks. Different version, same color, exactly you can see. But the taste also was much more better than Starbucks. Price cheaper than Starbucks. Okay, this cups, there is a variation. What we can presume here? Anything we can. You have liberty to interpret in the way not when the way interpretation of statutes happen.
She has a bag by her leg side.
Bag?
There is a bag or a suitcase by her
Okay,
leg
okay,
side.
fine. With money?
Yeah, could be.
Okay.
Mediator seems biased.
Yes.
Mediator is biased. See that? If you allow me, that is okay. With the liberty, with the disclaimer, that obvious, the head has to turn here, not here. It's not on the regarding the case. What difference you can see here? What things you can further?
Financial status.
Pardon?
Financial status.
Financial status, okay.
4A is missing there.
4A.
Yeah, you mentioned previously
Hmm.
acceptance, approved, authenticated,
Oh,
and authorized.
okay.
So
One thing is missing or
4.
4 are missing?
Yeah, 4.
4 are missing, okay.
না জোর করে করতেছি তো
Okay. Before analyzing this, there is one common say if you are dealing with family disputes,
Yeah.
particularly divorce, they will try to say as lawyers, no, I'll come to the different things. If you have a high-rising building, don't go to the second floor or above. As mediators, you will be thrown out. Now come to this point. All the persons seems to be formally dressed. All the person, or at least these two persons, are enjoying the cup of whatever coffee or tea.
Different things, not same things.
Pardon?
Different things, not
Different things, fine.
different things.
Different things. But the handshake is not the. Can you close? The person is operating there. Can you? Pen and paper. Okay. Laptop. Uniform. At the school. If I am in a situation, I need to have the best smartphone. I want to have the X Fold. I want to have the OnePlus Open. I want to have the iPhone. Now iPhone is boring. Because now I am having nothing to. The promoter says that why you are not opting, how you can market, you are saying iPhone is boring. Same design. As a student, you want to have a smartphone, the best smartphone in the world available in our hand. No, dress code, uniform, laptops, that automatically comes. That is default. Here, as a student, how you are going to procure or purchase that? How you are going to purchase? The best source is parent, because she can't steal, she can't borrow, she can't avail finance facility from all these banking institutions, financial institutions. No one would give loan. No one, as a student, no one would give. But there are apps, there are money apps, but your data would be stolen. As a student, our source is parents. Who's the soft target? Mother. Always for boys, mother.
Yeah, that's what.
As a soft target, mother, we can approach. How we are going to convince your mother to get that fund? How you are going to do it? This is the something related to this. I'll come to that point. How you are going to convince your mother?
I'll be better at my
Making
studies.
my mother
Huh?
a mediator.
I'll be better at my studies if you give me a
I'll be
better at my studies.
a false
That's a
statement.
convincing one.
I will do better. I will achieve. I will get above 80 or above 90% mark,
I will use the
which is impossible in law school.
connect with you all the time.
Pardon?
I must connect with you all the time.
Okay. Connectivity is a rare thing. Okay. Good performance in college, 10%. I will be connecting with you, obviously 5%, 15.
Use that for educational purpose.
Okay. I will get that instead of spending time in library, the best one,
Online versions.
comfortable on my transit. I'll just enjoy reading and I'll perform well. Another 5 only, 20%.
I'll stop studying.
Huh?
I'll stop my study so that.
Okay, returning.
Emotional blackmail.
Emotional blackmail. See a senior practitioners past.
Yeah, another one will be.
Okay, that obviously 10%. Because their main objective was to make you educate, become a lawyer. Oh, then fine, then 30%. Yes.
Another one is you can save your money for buying books. So this will be
If you say that,
yeah.
you say that, hypothetical situation, either of your parents happen to be a lawyer, they will have books, and they will have the best phone,
Yeah.
and they'll say, instead of buying that, this is the best phone in the world, which your father has given to me. I will give it to you. That will happen. Don't take the chance. 30% only. Another 70 is there. How to convince?
He was saying he would do online classes, that's why he.
Now the situation is that we are forced to online. If you look into the laptop or the PCs, my example is that before that I was not wearing specs. After COVID and online all these hearings, now it's a thick glass. 4 years have changed. I'll spoil my eyesight. You better get me a best mobile, which is all have the features of UV protections, all these protections.
Is that
Fine.
crying?
35%.
Is it crying and stop drinking
Ah.
and taking food?
Strike. Harta. Hunger strike. If I am in such a situation, my mother said, oh don't. 1 day is enough for me. If with due permission I can take the youngest student here.
Take more money.
5 days, no problem. Hunger strike. Okay, to some extent, another 40%.
We can offer politely. I need one. Please, can you give me one?
Okay, compromise. Compromise. In our faith, when you go to the temple, we forget all the things and we just lie down on the floor.
Sorry.
God, save us. We will do all the sin, but still you save us.
Sorry.
10%, 50%. Another 50 is there.
If you buy me that, I will abide by all of your instructions.
I will be obedient. Rare. 10%, 60.
Just to be connected, you need mobile.
I have to be connected across the world.
No. With your phone.
Oh,
You need to know where I am.
that's what the smart way of saying I will be connected. If a person wants to be connected, phone, you can't get away. As parents, we will be cautious. Earlier days, we are not having these. We had to go to some destination and make trunk calls or whatever, dial-ups. Now, with the mobile, the smart way, the parents, what they do, I will give the mobile, but the GPS location has to be on. Turned on. If it's off, we can't find where they are. Or else, okay, I am in the library, but actually he'll be in
That much educated.
that connected. Not educated. Reasonably, another 10%, 60, 40% is there. How to reach?
Give her a share of the money.
No. Mother is the powerful person in the home, even though she is so-called, no, I am the worst treated here. She is the Karta. She is the leader of that family. Father is just a puppet. Obviously, the fund, the resources, all will be in the mother's hand. No doubt. It is true. All will accept. Yes. 70%, you can take that also. 70%, 30% is there.
Appointing someone who is the influencer.
Pardon, I couldn't get it. Appointing mediator. Yeah, that's what I heard earlier.
Father is the mediator.
Here, that's what I told. Father is a puppet already. Huh?
Child be able to
Okay.
do all the words as a child. What my parents
No, I'll come to that point. We all think that mother's a soft target. Nowadays, mothers are also earning. Assuming that she's not earning, still, the entire money would be in the hands of the mother only. But we think, as kids, it is in the father's hand. The father, getting from the father is quite tough. But actually, it's tough from the mother. But with all these, we can reach a reasonable level. These are all just a negotiation technique what we try. Compromise force, coercion, threat, whatever, all these we tried. Something unrealistic, that is mark. Getting good marks is unrealistic. We can't get marks in the law colleges. And nowadays the law schools are better. Law colleges are 50% is a good mark. All these are just a negotiation technique. But still, in negotiation, there is no third party involved. We can't bring a third person. Here, mother and the son or daughter. Only these two parties. This process is always there in all the contracts, whether a commercial contract or the largest contract, wherein the disputing parties can try it. If it couldn't resolve this, then a third person comes to play. That third person, here the 30% cannot be. That third person is who in this situation? No. Father, no. Huh? No. Worst person. The best person would be the grandparents. The grandparents comes as mediator, and the grandparents has a version to say, those days I didn't give it to you, now I will facilitate to the grandchildren. Simple thing, and they are the best person to resolve and amicably solve the issue, settle the issue, and that person would get the money, but not the entire amount, a part of the amount. That is possible. This technique, this process, this skill, obviously we have to possess, and attempt to negotiate the issue through mediation is what you can derive from this. The various techniques we have, layer by layer, has to be facilitated by the mediator, and the outcome might be multiple. Here the outcome, the fund, the money required, or sometimes it can be also be purchased and given, or sometimes any alternative can be provided. Multiple things are there to be given, and the outcomes might be several. The best one, it is left to the parties to choose. Here, this person, the mediator, is giving multiple outcomes, and out of the multiple outcomes, one is presumed to be accepted, and it is being drafted in that agreement. It might be signed. By the parties. Once they sign, that becomes the term mediated settlement agreement, which is commonly used as MSA. MA is different from MSA. Keep that in mind. MA is mediated agreement or a mediation agreement, and MSA is mediated settlement agreement. You have to have a clear distinguishing factor of these two, or else in our common practice we try to mix it up. If it is MA, it is just a mediation agreement or a mediation clause. If it is MSA, it is the outcome of that mediation process, mediated settlement agreement. Be cautious while interpreting the terms and the deliberations or the outcome given in the mediation process. Phase 2 of the MEDA. Phase 1 was dispute remained unresolved. The process is yet to complete. That is, isn't over. Parties now move to arbitration. Either the mediator shift to the role of arbitrator, or the new arbitrator is appointed. That is very important. We are not stopping the process, because that process is titled as MED-R. If the process is titled just mediation, then it is over. Success or failure, it is over. If it is just arbitration, its outcome is award. We have a final outcome. But when it is met-r, if there is no MSA, there will be MA, not MSA, then the process is still there and we have to start the arbitration. We need not go to the courts. Very important. Going to the court doesn't arise. We have to go to arbitration. Option is given, but don't try to have the same mediator as an arbitrator. You appoint a new person as an arbitrator. The new person would be the better person to resolve the dispute because he is going to give award. He is not going to give or facilitate a MSA. Why? Here comes another component in MEDAR. I'm not sure about the provision. She was mentioning about 45.
Basic 45 is about recognition
Settlement.
and enforcement of foreign acts.
Which provision is dealing about settlement in arbitration? Act 2001. Can you recollect? It starts with, it is not incompatible for the parties to try mediation and conciliation in arbitration. MEDAR also includes that. We have done mediation. In mediation failure, then we go to arbitration. In arbitration, we can also once again try mediation with that arbitrator, the new arbitrator. The arbitrator can relax that provision. It is in UNCITRAL Model Law, Article 30. UNCITRAL Model Law on International Arbitrations, Article 30. It is there, I think. It is there in your Arbitration Act also. Here, the mediator once again transfer himself as a, the arbitrator once again transfer himself as a mediator. But he is a new person. He can try to mediate or conciliate, and that conciliation or mediation leads to a MSA, but that MSA won't be called as such a settlement agreement. It will be called an award on agreed terms or consent award. I think it's there. I happen to see in your Arbitration Act, consent award. It's called award on agreed terms in other jurisdictions. Mediation, arbitration, once again mediation. This component is R-MED. First we saw MED-R, then R-MED. This is where we need to have a separate person acting as mediator or arbitrator, because this person also is trying mediation, but his basic capacity was arbitrator. Mediator as arbitrator. Mediator is appointed as the arbitrator. The mediator already cleared the facts and knows the party's proposal. It might be cost effective than appointing a new arbitrator. And getting back to this version. Yeah. Appointment of an arbitrator in MEDAR, a person mediator, a person arbitrator. If the same person wants to be appointed as an arbitrator, proposal. As a settlement, they would have given certain things. They would agree saying that, oh, might be, I have done something wrong. It is my responsibility which I have breached. Such a things he might try to mention. The parties, either of the parties would have given, that input would be there on the the mediator's decision-making process. That should not influence, because the proposal, the party's proposals are already in the mind of that mediator. And if you appoint, fine, still it is cost effective than appointing a new arbitrator. Some additional fees for it so that we can manage. But this is a positive one I have given here. If another person is appointed as an arbitrator, instead of that mediator, a new person is appointed. it is good appointing a new clause. What is the advantage of MEDAR? These are the three: flexibility, finality, and beneficial, not for the parties but for the society. Flexible. To what extent it is flexible? A party need not be represented by a lawyer in mediation. Need not. The parties can take their case on their own. The parties need not follow civil procedure code. If you are not going to follow the civil procedure code, that itself is a great relief. The flexibility comes. Too flexible. To the extent that we need not go to the court campus to sit and mediate. Mediation center gives the space, but we can also do it in any location. There is no restriction. That flexibility, procedure, the place, whom we are going to appoint as a mediator, a judge cannot be appointed by us. Even if there is an opportunity given, there are certain criteria a person to be appointed as a judge. It's like a constitutional authority. We can't just easily go and be appointed as or considered to be a judge. The flexibility is 100%. There is no rigid procedure. Guidelines are there. If you can't find the guidelines, help you. Finality. Your matter resolves that. There is possibility to challenge, but that challenge is on procedural grounds. Very limited grounds are there, like arbitration, mediation, settlement agreement also is possible to be challenged under the Singapore Convention. We have to adhere to these conventions, and the conventions permit how, what time to take it for challenge. It's a limited grounds are there. It is beneficial, obviously, if the society is having limited disputes, or if the disputes is being resolved reasonably without disturbing the judicial system. That is the greatest benefit what is being given to the society. The courts are overburdened. Try this. It is very successful. I have only 5 minutes to complete. Okay. Men are men are. MEDAR is what the clause the gentleman the last mentioned. Are meant is what I think, can you find out that provision in the Arbitration Act?
Yeah,
You found it? Okay. That provision for arbitrator turning into mediator and trying to resolve. Then are meant are. In arbitration, we did mediation, and that mediation ends up in a success, and that outcome MSA changing into award on agreed terms or consent award. Start with arbitration, change into mediator, then the same person get into as arbitrator and write an award, but that award is based on MSA. That is called award on agreed terms or consent award. Very important. It is accepted internationally. No country objects or gives a possibility for the courts to challenge a settlement award or an award on agreed terms. Very important. All the three are significant in our practice. As mediation or future mediation practitioners, you have to be familiar with all the three. MEDAR, ARMED, are. It is globally accepted. In ARMED, arbitrator proceeds with the arbitration procedure in due course, attempts and allows the parties to settle the dispute through mediation. In ARMED, commencement arbitration, that is, it commences from arbitration, then is referred to mediation. Settlement agreement of the mediation is recorded as a consent award. Award we can see only in arbitration, not in mediation. Three combination, are, MED, are. This is wonderful. but MEDAR is comfortable. Which one you are going to choose? Comfortable one or a wonderful one? Both are good. If your dispute is quite smaller or your contract value is smaller, go with MEDAR. If your contract is quite a high value contract, then go with R-MED-R, because it has much value than MED-R. Okay. Here is a model clause of an institution. You can just take a picture of it. Taken from Singapore International Mediation Center. It's a combination of Singapore International Arbitration Center as well as Singapore International Mediation Center. Singapore Arbitration Center and we made a consent award on agreed terms. Wholesome. You try MEDAR, you can try R-MED, you can try the best one R-MED-R. But mediation and arbitration are complementing each other. This is very important latest development. But for our understanding, to begin with, we have to start with MED-R. These are some examples of Singapore International Mediation Institute, SIM, right? Can anyone close the door? Here, they are giving certain standards why the Singapore Mediation Center is quite popular. Anyway, sorry, you can just look into it. Now they wanted to foster a strong mediation community in Asia by engaging stakeholders in discussion events and outreaching. That is the main objective. Now we have no other option in international contract. We have to have MEDAR clauses. R is quite advanced, but MED-R clauses we have to accept, we have to acquaint ourselves, and we can flourish. With these few words, I am just concluding my sessions. Thank you. Thank you for.
Good afternoon. I hope you are having a good time. I am sorry for the delay in my presentation. I just landed from Kolkata, so please forgive me if I am still in that transit zone. So I think we have already started with the training since yesterday, right? So I'm pretty sure all of you must have developed a bit of an idea. আপনারা সবাই মিডিয়েশনের ব্যাপারে কিছুটা তো আইডিয়া ডেভেলপ করেই নিয়েছেন, সবাই মিডিয়েশনের ব্যাপারে কিছুটা তো জানেন। So can I have somebody, আপনাদের মধ্যে কেউ যদি বলতে চান যে আপনাদের এখন অবধি কি ধারণা বা আপনারা কি বুঝেছেন মিডিয়েশন বলতে গেলে? Yes, please. Can I share my one of the parties mediation and আজকে আমরা যেটা করেছি সেটা হচ্ছে arbitration and mediation and both কিভাবে combined ওয়েতে আমরা কিভাবে কনসিডার করতে পারি আর কিভাবে আমরা এগুলোকে অ্যাপ্লিকেশন মানে ক্লায়েন্টের সাথে রিলেশন করে আমরা অ্যাপ্লিকেশন শুরু করতে পারি। So these are the basics and mediation and arbitration এর মধ্যে কিছু ডিসটিংশনস গুলো আমাদেরকে দেখানো হয়েছে যে আলটিমেটলি যে অ্যাওয়ার্ডটা দেওয়া হবে রেজাল্ট যেটা হয় মিডিয়েশনের ক্ষেত্রে হয় সেটা সেটেলমেন্ট and arbitration ক্ষেত্রে সেটা হয়ে যায় অ্যাওয়ার্ড। So these are the basic things that we have learned so far. That's great. Thank you so much. May I have your name, please? Joya. Thank you, Ms. Joya. So what you are telling me is you have got to know the definition and the framework of mediation, right? But what I'm trying to understand is, do you understand that mediation is just as a process? Don't get into the definition of it. Just what do you feel in mediation? আপনাদের হিসেবে কি মনে হয় মিডিয়েশনটা কি? You can give me an example if you want. মানে আমাদের day to day লাইফের মধ্যে থেকে an example. Somebody raised a hand.
By mediation, we understand when parties are having dispute, it will be intervened by a third person as a mediator who will assist the parties to get into a solution, multiple solutions, and the parties can choose which solution they can have.
Okay, that's correct. But when we say that a third party intervenes,
আমাদের বিষয়টা যেটা সেই বিষয় ভিত্তিক আলোচনা চলছে অবশ্য অনেক প্রশ্ন আমাদের আছে। আমার বিশ্বাস ওনাদের সেশন কমপ্লিট হওয়ার পরে যদি কোনো প্রশ্ন থাকে তার জন্য কিন্তু লিখিতভাবে আপনাদের কাছে আহ্বান করা হবে টুমরো একটা প্রশ্নমালা দেওয়া হবে এবং তারপরে আপনার সে প্রশ্ন রাখবেন এর জন্য অনলাইন ক্লাস থাকবে। সুতরাং মানে ওনার ক্লাসটা ওনার মতো করতে দিন আর আমাদের অনেক প্রশ্ন থাকবে সাবজেক্টটা মাথায় রাখবেন মিডিয়েশনটাকে উনি কীভাবে নিয়ে আসছেন দেখে নিন এই আমাকে প্রশ্ন হয়তো আমি করতে পারবো সত্যি কি কথা সুতরাং আমি প্রশ্নটার আগে আমি জিজ্ঞেস করবো মিসকে
so mediation, this intervention that is happening from the third party, one thing that I would want to point, this intervention doesn't happen on itself. The ideal definition of mediation is when the parties want the third party to intervene. দুজনের মধ্যে ঝামেলা হচ্ছে, কোনো কনফ্লিক্ট হচ্ছে, তো এবার তার মধ্যে যখন থার্ড পার্টি এন্টার করবে সেটা থার্ড পার্টি ডিসাইড করবে না যে হ্যাঁ ওদের ঝামেলাটা আমি মিটাবো, আমি মিডিয়েটর হয়ে ঢুকে পড়লাম, সেটা না। আইডিয়াল ডেফিনেশন এটা যে যখন ওই দুই পার্টি যাদের মধ্যে ঝামেলাটা হচ্ছে ওনারা যখন একজন থার্ড কারোর কাছে যাবে, গিয়ে বলবেন যে দেখুন আমাদের মধ্যে এরকম সমস্যা হচ্ছে, আমরা সেটা সমাধান করতে পারছি না, আপনি এসে আমাদের ওটাকে সমাধান করতে হেল্প করুন, that is the ideal definition of mediation. But when we have to bring it into the system, when there has to be a law established around it, of course there has to be certain rules that needs to be set for the mediator to be appointed, right? Well, this is not exactly what I'm going to be talking about today. My topic is basically going through the story of mediation. Now, when we talk about mediation or when we are doing these trainings of mediation, we usually believe that this is a new process which we need to inculcate. That is a myth that I am here to break. It's not a new process. It's not a process from the West per se. It's a process which was there and it has been embedded in our history for ages. Right? এটা প্রচুর পুরনো প্রাচীন একটা ধরনের প্রসেস, বিভিন্ন সিভিলাইজেশন মিডিয়েশনের বিভিন্ন ভার্সনটাকে অ্যাডপ্ট করেছে। সেইটা হলো সেই জিনিসটা নিয়ে আমি আজকে কথা বলবো, ঠিক আছে? এটা শুরু করার আগে I will start with a very small story. If you have not heard, just correct if you have heard the famous orange story of mediation. Okay, so let me just break it down for you. There are two kids, bhai বোন, and বাড়িতে একটা কমলা লেবু আছে. I'm sorry my Bengali is a bit different. So it's okay. If you understand that solves the problem. So এবার বাড়িতে একটা কমলা লেবু আছে এবং দুই ভাই বোনই সেই কমলা লেবুটা খেতে চাইছে। এবার সেটা নিয়ে স্বাভাবিক মারপিট ঝগড়াঝাটি দুজনের মধ্যে হচ্ছে। তো যখন এই ঝামেলাটা চলছে, then the father sees যে বাচ্চারা এরকম করে ঝগড়াঝাটি করছে কেন? So he calls them up and he's like, what do you want? Why are you fighting? So both of them say যে আমার ওই কমলা লেবুটা লাগবে, I want that orange. So father, as anyone else would, he knows it's one orange and I have two kids. So what he does is he divides that orange in half and he gives it to both of them. Right? Rational decision. So that he does and he goes away. But the kids are still not happy. Why are they not happy? Because they wanted the whole orange. They didn't want half of it. So they are still grumpy. They are not talking to each other. They are not playing with each other because now they have a strained relation. Correct? এরপর মা দেখতে পাচ্ছেন যে বাচ্চারা নিজেদের সাথে কথা বলছে না, they are not playing with each other and they are a bit sad and grumpy. So she goes around and asks, what's the issue? কি হলো? Both of them say that we wanted the orange and we didn't get it. Then she asks, why did you want the orange? So when she asks, why do you want the orange? যে ভাই সে বললো আমার আজকে অরেঞ্জ জুস খেতে ইচ্ছে করছে, আমার খুব গরম লাগছে, আমার আজকে অরেঞ্জ জুস খাওয়ার ইচ্ছে. So she understands, okay. And then she asks the sister, why do you want that orange? So she says she wants to bake an orange cake. She wants to bake an orange cake. So she wants to make marmalade out of that orange peel. So then what the mother does, she takes back both the half oranges. She gives the skin to the daughter. Because তার শুধু এই চোকলাটাই দরকার ছিল, তার ভিতরের পাল্পটা দরকার ছিল না. And she gives the pulp to the brother. কারণ জুস বানানোর জন্য চোকলার দরকার নেই. And now both of them are happy. Because now they both have what they want. Right? It's a very simple story. Real life situations are not as easy. It's way more complicated. There are multiple layers to it. But always, the thing is, humans always have priority. We always know this is the thing that we want the most. Right? And then we have a list. But when it comes to conflict, we want everything. So to help someone process through that, it just makes this entire equation and helping resolve them makes it much easier. Okay, now if I talk about the history of mediation and when it started or where it was, it's a very interesting space. Did I change?
Next slide.
Okay. So it's said that where there is a human being, there is an opportunity for a conflict. Conflict is an opportunity. You must have faced this sometime in your life, যে আপনার সবচাইতে প্রিয় বন্ধু, সেই প্রিয় হওয়ার আগে তার সাথে নিশ্চয়ই কোনো না কোনো ঝগড়া বা কিছু একটা ঝামেলা কখনো হয়েছিল. And both of you had a lot of fights during your childhood. My best friend, I used to fight a lot. And then we kept on resolving, and now we have a bond which is unbreakable. So conflicts are opportunities, right? Now, let me get into this. So this is a perfect definition of what is mediation. I'm not going to delve too much into it because we will be studying it through and through the sessions. What are the benefits of mediation? The first and foremost that I say is preserving relationships. When we go to any other format, we destroy relationships. So if one has to say, when it comes to relationship, is it only family matters? No. In commercial disputes, don't you think people need to be in relationship to have cordial business deals? You need to be friends with your business partners. You need to have that rapport, right? So the moment we talk about relationships, a lot of times we think that, oh, it's only for family, mediation is not for anything else, but that's wrong. No, no. When you talk about the disputes between countries, don't you think preserving relationships is of utmost importance? Right. So, this is one of the biggest benefits according to me. Second is cost effectiveness. Well, we all know the cost of litigation. Fortunately or unfortunately, it is comparatively much lower in the South Asian countries like ours, where we can just go to the court and file a matter. But if you go to any other country or the European countries, the cost is extremely high. The lawyers cost around $300 to $500 per hour. People literally go bankrupt trying to get into litigation, right? So cost effectiveness is definitely a thing that we need to consider. Also, now that we are turning into global citizens, right? It's very common for people to go and settle abroad. অনেকেই আমরা আমাদের বাড়ির মধ্যে অনেকেই যারা বিদেশে গিয়ে সেটেল হচ্ছে। So if we think about that, and if say somebody from here is going to some other country and they have to go through a litigation there, or they have a litigation here in Bangladesh and that person is settled in say London. So there's a lot of cost involved, right? So that is one. And of course, empowering the parties to their solution. After the resolution happens, parties do not feel they are obliged. They are happy to do what comes out. Of course, that's also an ideal statement. That doesn't always happen in real life cases, but that's what we aim at and that's what we target, right? Okay, so now we talk about the ancient roots of mediation. So Well, if we talk about the Greek city, this term called synagogue, synagoroi, sorry, I am having some hard time having to pronounce that, right? So it's synagogue. So this is basically a person who has acted as a mediator. If you read into the Greek mythology and the stories there, you will realize this is one of the most important persons in the king's court, right? So he was basically spokesperson. Whenever somebody had to come for a dispute to the kings, they used to have this person who would talk for them, be their spokesperson, right? Now, you would say that if this is the person that is an advocate, then how are you saying that this person is also a mediator? Well, the understanding of the process or the written legislation at that point, whatever we can find, it says and points out to the fact that these people who were the court-appointed personals or advocates were supposed to be ensuring that mediation or a sort of resolution happens first before the king would go and make a decision, right? So it was a process. Now that definition of mediation might not fit into our current definition of mediation. But at that point of time, this is what the society was in a format and this is what it looked like, right? I understand all of you must be a bit sleepy. It's right after lunch. So please hold your horses. And if you want to speak in between, you want to share something, please go up ahead and let me know, right? Okay, so this is one from the Greek history, right? Now, if we also talk about the Roman Empire, I'm talking about all age-old places, right? So if we talk about the Roman Empire, in ancient Rome, the mediation process was formalized through the appointment of arbitrators known as judices. And they have an entire legislation. Obviously, I can't pull up that entire document here. It will be, rather I would say, boring for everybody to go through it. But the crux of the matter is, even back then, this idea and ideology of what mediation is was very much prevalent and much in practice, right? So the Roman mediation traditions were applied to a wide range of disputes, including civil and private matters, right? And the concept of concordia, which is by meaning harmony or agreement, played a central role in mediation. Basically, the Roman law recognized and provided a framework for mediation and arbitration. Arbitration was also there at that time, right? And acknowledging the value of consensual dispute resolution. The process allowed parties to maintain a level of control over the resolution of their conflicts, right? Now, the Code of Hammurabi. When we say this is the modern format for mediation and this is the upcoming training and all of it, can you imagine mediation has also been engraved in the stones? We literally have evidence of that. So the Code of Hammurabi is one of the earliest and most complete written legal codes dating back to the ancient Mesopotamia around 1754 BCE. It is often characterized, so during the reign of Hammurabi, the sixth king of the first Babylonian dynasty. Now, Babylonian dynasty, if you have ever read about it, it's a very brutal dynasty, okay? And people were given very harsh punitive punishments. People were beheaded, and those were real physical tortures that used to happen. But even then, there was a space where civil disputes regarding land or holding of land or property, had to be mediated first. So even when we talk about the period which had a lot of punitive punishments, even then mediation was in picture, right? The Code of Hammurabi is often characterized by a form of retributive justice where the punishment is intended to fit the crime. It outlines specific punishments for various offences with an emphasis on the principle of an eye for an eye. So imagine the brutality at that point. It was written an eye for an eye. So when people used to follow that, the extent and limit of it. But even then, there was reference for mediation and there was a space, safe space given where the parties, if they wanted, they could actually help resolve and not get into this entire juncture. Well, mediation in Asian cultures. So the Confucian principles and Taoist philosophy have profound implications on mediation. Well, mediation has been here in the southeastern countries for a long time. I am sure we also had a mediation way of Bangladesh. Can someone say what it was? Yes. So we do have that as well. So, well, Southeast it was very common, and it is also embedded in the philosophies of the East. Well, I heard this from one of my trainers during my mediation, and they said if you add a T to mediation, it becomes meditation, which is also required, which is time. So T stands for time, and if you add cost, which is C, it becomes medication. So somewhere, you know, that philosophy of looking within yourself, trying to search your soul and trying to find peace was linked to this process of trying to settle that peace outside as well. Am I audible better? Okay. Thank you so much. Okay. So, now there's one story. So Confucius was given the job of helping resolve a dispute between two families. And what he did, hello? Okay. So what he did, instead of trying to resolve that, he invited them over for dinner. And they made them sit in a circle, and they made them sit with each other, like one person of the family, then another person of the family, and he mixed it up. Obviously, I haven't written all the details there, so. Sorry, I think I was losing my voice on that. So, what he did, he made everybody sit together, and he made them have a hearty meal. So obviously, they were irritated, or they were not talking in the beginning, as you know, there was a difference going on, but eventually when they started having the meal together and somebody appreciated the meal and the next had to do the same, and then eventually they started talking. And surprisingly, they ended up talking for a long time, and by the time the dinner was over, so was their conflict. So, this is just one example. I remember this from my childhood when I used to fight with my best friend and I would say I would not go to her place anymore, I don't like her and all that. My mother would specifically invite her and she would make the things that she loved to eat. And she would make us sit and just discuss probably projects or do anything as a child. We used to have those cursive writing books which I used to hate. So anyways, we used to do that, and by the end of that play date, if you say so, we used to be friends again. So it's a very simple thing. What I mean by that is, when we talk about mediation, if you are trying to isolate mediation from your everyday life, it might look like something which is huge and it's a big deal and all of that. But try to see it through the lens of your everyday life. Try to see it through the lens of your human relationships that you share. That's what these people did. So if I talk about the Confucian principles emphasizing harmony, so the first principle was Ren, which is benevolence. So connection to mediation. The Confucian concept of Ren emphasizes benevolence, compassion and kindness. I will not read through, it might be boring, so just take a picture if you will, and or probably we'll share the slides. However, you can read it through later. I'll just talk through it. Then we have Li, which is the rituals and courtesy. Then we have Zio, which is the filial piety, and then which is Yi, which is righteousness. And then we have harmony as a central concept. So the overarching principle in Confucianism is harmony, both within oneself and in relationships. As I said, this idea to find peace within you also reached to a point where they said, okay, try and find peace outside yourself as well. So basically, there's another story, and in this, there was a dispute over water between two villages. So they wanted to block the water, and I think it's still one of the long-standing disputes internationally as well between multiple countries. It's a way of tackling diplomatic situations, right? To block water or to threaten to block water. So anyways, coming to the point, so these villages had a dispute regarding water, and they went to the head of this village who was supposed to be taking care of their conflict. So when they did, this man just took them to this one place where there was water flowing, and he made them sit there. And they kept sitting to a point where they realized that the water is flowing and they don't have any control over its flow. So when you say that I will not let this flow to you, you are basically not in control of this. That mere realization, it's a very small thing, right? We all know that water flows. But sometimes we sort of glorify our place or put us in that place where we say, oh no, I'm going to control the flow and I'm going to stop it from reaching to you. But when these people were made to sit there for a really long time, they realized, okay, water is flowing good, okay, let it flow. It's a very simple thing, but it worked. There's another story. This Chinese fisherman, he goes for fishing, and he has a sort of a sad story. So his mother was very ill and she was aged, and his wife, they couldn't have kids. So the mother-in-law was always trying to torture this daughter-in-law, very, I don't know, very usual scenario, unfortunately. And so what happens, this fisherman goes to the sea and he's trying to fish, and he catches hold of this lamb. Now when he catches hold of this lamb, he tries to clean it because it was dirty and it was full of moisture and stuff like that. So when he brushes it off, a genie pops out. And the genie says that, excuse me. So the genie says that I will grant you one wish. Now the fisherman is really confused because there were a lot of things that he wanted. So what the fisherman decided to do, he requested the genie, যে আজকে আমাকে বাড়ি যেতে দিন, আমি বাড়ি যাই, আমি একটু এটা নিয়ে বিচার ব্যবস্থা করি, হ্যাঁ, একটু let me discuss it with my wife, সবার সাথে কথাবার্তা বলে, then I'll come back to you tomorrow and I'll let you know what my one wish is. So he goes back and he tells his family about the situation. Now the wife, she's like, why do you even have to think about it? You know we want a child, you have to ask for a son, that's what we want, there is no two thoughts about it, what is wrong with you? And then his mother is like, see, I'm your mother, I am so ill, why would you not want me to get better? What kind of a son are you? Now this man is in a total fix. So he is extremely confused, frustrated, and at that time he is thinking, I wish I had never got hold of that lamb. So, in his frustration and grumble, he goes to this common place where all the villagers sit in the evening and chit-chat. Their adda is always very famous. So they go for this usual village adda. And there he meets this old person who sort of realizes that this fisherman is a bit grumpy and he's not happy, and he wants to know what's going on. So he asks, and then he says, see, this is the dilemma. So my wife tells me to have a son, and my mother tells me to make her health better. Now come to think of it, both are very important, right? Like, I'm sure none of us could have decided if we were in that space. So this old man says, oh, it's such an easy thing, why would you even bother about it, right? And he hushes something into his ears, and this fisherman goes back to the genie next day very happy. So the genie is also sort of surprised that kalkei to ato ye korchilo and suddenly you're so happy, so tell me what's your first one wish that you want. So his mother actually had a problem in her legs. She was limping because of old age and stuff like that. So he's like, I want my mother to be playing around with my son in my courtyard. You see what he did? So he made sure that both the wishes are granted in one way. Do you think that could have been possible if you would have fought with the genie? If you would have said, no, why can't you grant me two, I deserve two. I have my wife, I have my mother, I deserve two, you give me two. No. He took his own time. Of course he was grumpy, but he discussed it with the elders. He sought the relevant advice, and now he has both of it. Okay. Moving on to the next slide. So this is basically the philosophy of the Taoist philosophy, and I think we have all seen that sign with yin and yang, and it's interpreted in multiple ways. But what the meaning of it is that there is always a balance in the universe. And whatever you do, whatever you want, whatever you are targeting, it always has to be within that balance. If there is moon, there is sun at the same time. If there is light, there is darkness. If there is no darkness, we won't see the light. And likewise. So there is this balance which has to be maintained. So there are a couple of theories and a couple of ideologies which talks about this philosophy. You can read better about them. I'll just go through slide 3. So number 1 is non-action or effortless action. Sometimes just doing nothing works. Okay, sometimes there are certain situations in life where you do not need to do anything. I'm sure even when you have, sometimes you do have clients or people who come up to you with problems and you're like, just let it sink for some time. Let it be, it will resolve. So that is also a way of sometimes settling things. Of course, doesn't mean that if there is something serious going on and you just say, okay, let it slide. No, that definitely not that. Then, yin and yang, as we talked about dualism, right? The balance between both the sides. Then we have Ziran, which is naturalness. So Ziran emphasizes embracing the natural flow of life. In mediation, encouraging authenticity and openness allows parties to express their thoughts. Say if we are in a mediation session and we want to speak, and in that process of wanting to speak, we are constantly stopping the other person, or we are interfering, getting in between. আমরা কথাটাকে বলতে দিচ্ছি না, বারবার তাকে আটকাচ্ছি। So obviously after one point the party will be like, ওর তো শোনার ইচ্ছেই নেই, আমি বলে কি করব? Let it be, right? So you have to let things flow as well. Then Tao, the way. Tao is the fundamental principle and it guides parties to discover their own way. Everybody has a way of being. Say I am a person who's, for example, likes to speak loudly. Doesn't mean I'm trying to disrespect or dishonor someone. If you talk about India, there's this state in India called Haryana. Okay? And Haryanvi people, they speak extremely rude. But that's their way of speaking. If you ever hear two people in Haryanvi having a conversation, you might end up thinking they're fighting with each other. They'll talk to each other like, kya chal raha hai? Like that, okay? So it's really harsh. So let's say somebody who speaks Bengali, which is a sweet language, if I can take pride in saying that. So imagine what the scenario would be. Say a Bengali girl marries into a Haryanvi family and she's having a usual conversation with her mother-in-law. Imagine the fight. It would be a disaster, but for no reason. Right? So sometimes we also need to understand that what the other person is doing doesn't really mean that they are trying to be hurtful. It's just their way. Okay? So it is also important to feel that. And of course, this emphasis on unity and diversity. Right, while coming on the way from airport, I was just having a conversation with Sharma sir, who's going to have a session with you tomorrow. And I just happened to comment saying that human relationships are extremely complicated. To which he said it's true. Mankind has developed nuclear bombs. We are landing on the moon, and we are also probably going to land on Mars. But we still can't establish world peace, can we? So it's extremely complicated, and so this thought of unity and diversity and trying to be in a symbiotic relationship is extremely important, and we need to find it. You know, and there are very small instances, I would say.
son. He's just 1.5, and sometimes when he's playing with other friends of his friends, as in my friends who have kids of similar age. So let's say he's just playing and somebody hits him. Kids have a tendency to hit each other. This is something I have realized, it's a specific. So when they hit, I feel very furiated. How can he hit my child? But my son, he doesn't really care, because for him it's a way of playing. But when I am putting my brain into it and say, how could he hit my child? I get offended, but my kid is fine and he is happy playing like that. So sometimes we have to understand that as well. We might find awkward situations where we're like, how can this person be satisfied or happy? How can this person want it? But it is probably the way, right? Okay, so now if we talk about mediation in indigenous societies, specifically these two, the Navajo peacemaking and the Ubuntu philosophy, these are very interesting once again. So let me talk about the Navajo peacemaking first. So in the sacred terrain of Navajo Nation, a conflict over grazing rights emerged. Okay, so let me just tell you a couple of things before we get into the storyline. So in this Navajo peacemaking, there's a very interesting slide to it. So if you look at all the other ways where there is any sort of conflict resolution, always the head person is a male. Like the most senior person. Even in India, when we have a panchayat system where 5 people coming, now it has recently become so that a woman is also included in that panchayat, but the sarpanch, the head of that 5-member group, is always a male. Usually. So, but in this Navajo peacemaking, the head was always a woman. And there's a reason behind it. The reason was established that women are more empathetic. They feel more. So if you're trying to resolve, where you are trying to talk about emotions, it is always advisable to bring that in. Now, of course, when we talk about equality and all of it in today's time, we expect men also to be handling their emotions as equally much. But reality is not that simple, right? So the Navajo lead was usually always the eldest lady of that village. And whenever a dispute would come, instead of going at the dispute directly or making them sit and talk about it, they would do rituals. They will make them sit, draw some lines, do 10 things together. By the time, I don't know whether it was sheer boredom or people were like, it's better to not get into these rituals and help resolve conflict. But by the end of it, the conflict mostly would get resolved. The idea is, if you are doing certain things together, see, we all have faith. And even though we have differences, we end up believing in that faith, right? If you have a friend, if I have to say, if anybody's a Shah Rukh Khan fan, say you have had a terrible fight with your best friend, and there's a new Shah Rukh movie releasing, and both of you are big fans of Shah Rukh Khan. I am pretty sure if any one of them proposes, okay, or a third friend says, let's go and watch Shah Rukh Khan movie, both of you would be ready. It doesn't matter, right? It doesn't matter if you're fighting with each other or not. Probably in that process of watching that Shah Rukh movie and discussing, I'm just giving very real life examples, okay? So in that process, oh, Shah Rukh was really so nice, oh, this action scene was nice, oh, this was not okay. You might actually end up resolving your conflict and say, oh, it was such a silly thing we were fighting about. Right, so this was the way that they tackled most of the disputes. Now, if I talk about the next one, the Ubuntu philosophy, I would suggest all of you to read about it, not because of mediation only, but it's a beautiful way of life. This philosophy basically believes in we are one. We are one with the people around us, we are one with the nature. As a small experiment, one researcher, what that person did, he gathered a lot of children from that particular African village, and he created this basket full of fresh fruits. And he added some chocolates to it, and all sorts of things that kids like. And so he placed it in the center. He requested all the children to form a circle around it. Now, there was a game. So the game was, once he says 1, 2, 3, go, whoever runs fastest and grabs the basket owns the basket. So he made this circle, let kids stand in a circle, and he kept that basket in the center. And when he said 1, 2, 3, go, he was expecting there to be a ruckus and to his surprise, none of the kids moved. They were still standing there. And he was shocked. He asked, what's wrong? Why are you not moving? Like, don't you like chocolates and fresh fruits? Or so one of them said, yes, we do like it, but we want to share it. And to his utter surprise, he's like, why do you want to share it? If you have that basket, you can, consume it for yourself and have it for days. So this kid says, how can I be happy if my friends are not? If I get that basket, my friends would be extremely sad. I would be very happy. So probably I would want to go and play. But none of my friends would be happy enough to play with me. So instead of grabbing that basket, why don't we share it with everybody so we all have a good time and make a memory? And this is a real life story that I'm sharing from a researcher's document. So imagine how much empathy and what sort of philosophy that village endured in their kids for them to understand that. And I'm not talking about kids from our families who can just get a 5-star just like that or get a Cadbury just like that. These are kids from villages who probably will never have access to those fruits and chocolates. I had a video, I'm not sure this will play because, but you can go on YouTube and it will change for you. So you can go on YouTube and just write Ubuntu philosophy kids example, something like that. You'll find a video which is relevant narrating the story. Right. Now, since we are talking about history, and I'm sorry, I know history is a tad bit stretchy and boring, but that's the basis of where it all starts. So please try to hold on to your senses and don't doze off. Okay, so if we talk about modern mediation, right? Now, where we talked about there were different variations of mediation and various sort of implementations of it. Now, if we come to talk about the modern day mediation, so this is where it started. So the early modern European mediation. Since then, mediation started becoming more structured. There was a format, there were written documents around it, which tried saying, okay, this is the way you have to resolve your family disputes, this is the way you have to resolve your property disputes, and it sort of started picking up the structure. This is the beginning of the structured mediation that I think all of us are going to be trained with, right? So, if we talk about the pioneers of... Okay, so before getting into it, this is the Peace of Westphalia. Okay, so the Peace of Westphalia was of 1648. It was revolutionized diplomacy, affirming state sovereignty and advocating for this peaceful dispute resolution system. This is one of the oldest piece of documents which formally has the structured mediation in it, right? The legal framework it established became foundational in international law, shaping diplomatic norms and favoring negotiated settlements. Now, development in the 20th century. Now, this formal version of mediation that we currently have, which obviously all of you will be coming across, where there's a certain way of sitting and there's a certain format that you need to follow. So this was all coming up in the 20th century. And during that development period, we have a couple of people who actually helped, scholars who had helped in creating those formats, okay. So one from the early 20th century is John Haynes Holmes and the labor management mediation. So the earliest emergence of mediation in the Industrial Revolution was to manage labours and unions. Because it was difficult. Try and think to take unions into the court is a big difficult situation. So that's where the structured mediation format started happening, where the union leader would come, would try to negotiate terms and, you know, probably discuss pay structures, salaries and stuff like that with the people who were in charge or the managerials of the industries and stuff like that, right? So he has documented this form of mediation first. Then we have the next, it's John W. Haley and community mediation. Community mediation is basically happening between communities when a certain set of, so the easiest example of community mediation is if you live in a big society, you must be knowing that there's a structure in the society where there's a secretary and then there's a finance head, treasurer and stuff like that, right? And you do have conflicts between neighbors, and then this entire structure sits and they try to resolve it, say parking dispute, or say somebody has had a dinner party at their place and it ran pretty late. So just like that, okay? And then William Ury, well, I think all of you must have known, if you don't know him yet, you should know him. He's almost like the father of negotiation. There's a book I'm sure that will be referred to you soon. You have to read it if you want to learn mediation or negotiation as well. Okay. Not getting further into his achievements. Then Jimmy Carter's Camp David Accords. So he was one of the former US presidents who actually started promoting structured mediation happening into the US legislation, and more so because he was using them to tackle geopolitical scenarios and conflicts between regions and areas. Then Mary Parker, Follett's early influence. So basically, she is more of a pioneer for negotiation, which is obviously, so if you think about structured mediation, let me just tell you this once, it is assisted negotiation. Okay, that's the easiest definition of what is mediation. It is assisted negotiation. So the principles that we apply during mediation are all the important basic principles of negotiation first, because if you don't know how to negotiate, you would never be able to mediate. That's the basis of it, right? So she is more of the pioneer who helped develop the negotiation theories as well. Now, mediation in legal systems, well, now we already know that our codes and documents and legislations has mediation written in them, and there are countries like Sweden where, well, I don't think that's mediation per se, but that's a way of dispute resolution. So if you go to courts in Sweden, the judge will first try to resolve the matter before taking ahead and going into litigation. So the judge will first act as an arbitrator. They term it as mediator. I don't believe that's mediation. So, but anyways, they act as an ADR expert. And then once they know that this is not going to resolve, that is when they pick up on litigation further. So there are systems like that. And we do have the global trend of mediation now. Mediation is definitely picking up. The biggest document is the Singapore Convention. If you want to read about the law behind mediation and how structured it is, and if you want to know which countries, India has already signed. I'm not sure if Bangladesh has signed the Singapore Convention, but probably Bangladesh will, because it's becoming one of the international norms of mediation. Now, court-annexed mediation programs, right? So the US federal courts offer court-annexed mediation programs encouraging parties to explore mediation. So what happens? In a lot of courts, specifically family and civil courts in US, when a matter is lodged in front of the judge, they usually always ensure that mediation has taken place before the matter starts. If, say, it hasn't, then the court will request the parties to either look out for a mediator, or the court will self-appoint a mediator. And if it still doesn't go through and the mediator signs at the end of that mediation saying that, okay, this is not getting resolved, that is when it comes back to the court, okay? Mediation as a mandatory step, as I said, in Italy, also in Sweden, in most of the Scandinavian countries, mediation is the way, and they are trying to reduce the load on courts enormously, and they are being successful in it as well. Now, institutionalization of mediation services. If you have read about NCTC, this is just one of the committees, like how wonderfully Goswami sir is doing BRIMS here, and he's trying to promote. So this is basically an institutionalization of mediation. You are trying to create an institute and trying to promote the process, bring members on board so that people start practicing. So there are international associations like that as well. We also have another here, that is AMA, which is Africa Asia Mediation Association. So stuff like that. So that institutionalization is also happening. Now, in terms of trainings and certificates, the current trend, we have certain international institutions, IMI, which is the International Mediation Institute, which is considered to be one of the biggest mediation institutes across the world. So they give this trainings and certifications, and we have other institutes as well. Like how we are doing this particular training under BIMS. So this training is also going on because currently the mandate is to have 40 hours training before you can go ahead as a mediator. Right. And then we have the recognition of international standards. So in India currently we have a new legislation come up under consumer law where mediation has been made compulsory for any consumer dispute to happen before going to the consumer court. Now when the draft is done, it has taken its, how do I say it, it has taken its extract a lot from Singapore Convention and also from the model law in UNCITRAL. Also, any international litigation that happens or any sort of dispute that happens over IP rights, intellectual property across the world in WIPO is always mediated first. Okay. So these are a couple of things. Now, if we talk about ODR, I think we have started on this topic the moment COVID came in and people realized that online is the platform and online has to grow. So earlier, earlier when ODR came into picture, there were a couple of questions. Now say, when you do mediation, it is a private affair, right? Nobody can be present in the room. But let's say you are doing a Zoom call and video call and there is somebody in the room. Then what? Private room, right. But private room, when people are physically present, say I have a dispute with you, right, and you are in Dhaka and I am in Kolkata. And we want to resolve that dispute. And you are sitting on Zoom call, say you are saying you are in a private room, you are in a private room. I say I am in a private room in my house in Kolkata, but I am not. Right? Maybe I am recording that. One thing to understand, any recordings coming out of any mediation sort of a setup is never admissible in the court of law. That's one way. Another thing that started happening with ODR platforms, Zoom launched a platform, I think 2 years into COVID, when people had realized that COVID is not going away that easily. So we have to find that way of life. So Zoom launched a platform for mediation where it actually had private people and they used AI, so as to say in the easiest way. They basically used AI to find if there is anybody else in the room. So they would detect any movement, any change in voice modulation. Because it so happens, if there is another person, and I'm saying that I am not having anybody else in the room, but if there is another person, sometime or the other my body language will change in a way that I might want to point out, or say the other person is saying something important and I want this third person who is not there to listen to it, right? যাকে লুকিয়ে রেখেছি তার দিকে কখনো না কখনো তো আমি ইশারা করবই. So these sort of things are happening, and they were also doing, so once you learn more about mediation, you will also have these single sessions, split sessions just with the mediator alone. So আগে কি হতো, when it started initially with COVID times, normal Zoom call করা হতো and say you want to have a one-on-one session with the mediator, ওই common callটাকে drop করে you would do a one-on-one call with the mediator, then that would end, then again a group call will start. But that changed. The platform introduced single rooms as well. So you could enter into that room with the mediator, the call is going on, and then you come back. So a lot of these changes were happening. And obviously, because ODR is different from being physically there, the laws also needs to be different. So you're not signing an agreement. Say I have a dispute with, say, you for 5,000 rupees, right? And after that mediation, you tell me that, okay, I will give you the 5,000. and you say, I will internationally, I'll do some transfer internationally. Now there is no way of assuring that international transaction has happened. If you are physically there, we can say you can give a blank check at a post-dated rate, right? You give me a check saying that okay, after 7 days this will, because if it bounces, it's a criminal act, so you will not do that otherwise, or you pay me in cash or however. So online situations were definitely different, which is why they also needed different set of rules. The first most important thing was to recognize online mediation as mediation. So we have this legislation which is coming, which is in India, and we also have an online ODR legislation, an international framework, where the definition of what an online mediation is, how to conduct it, you know, what are the norms, and all of it is also there. So this is the current, if we say ODR is the current situation of mediation worldwide. Okay. Now, the integration of mediation into legal system reflects a global shift towards more collaborative, efficient, and flexible dispute resolution processes. As legal systems continue to adapt and recognize the value of mediation, the field is poised for further growth and acceptance worldwide. Well, now, what are the emerging trends in mediation? So, 100% the thing that is happening is we are becoming global citizens. We are moving across countries. There are people who are working in companies. I'm sure a lot of you know people who are working in IT sector. They are posted somewhere in US or in UK, Canada. People are moving to study. So we are all moving around. And so we are now more so becoming global citizens, right? So the moment we become global citizens, so I'll just give this example to you. I was there in New Zealand for a brief period of my career, and when I was there, so we had a dispute between the senior lawyer and her PA. Now, the senior lawyer was Australian, and the PA, she was Japanese. They had problems. This lady would usually come up and cry, and she would be, sobbing, and she was really unhappy. And whereas this man never realized there was any problem. Anyways, what happens is, since this problem kept on escalating, one fine day this lady decides to leave her job. So she's like, I can't do this job anymore, and I'm done with it. Now, when she decides to do that, obviously the other people come in because this lady was very efficient. So why would she want to leave the job? And as South Asians, when we go to countries like New Zealand and stuff, we want to settle in. And it was a good flow of money, so nobody could really understand what was going on and how deep that conflict was. So what happened is somebody in the firm decided to help them resolve their dispute, and was a self-appointed mediator. Both the parties agreed, saying, okay, fine. Now, when that mediator was being chosen, it was a lady who was Chinese, but she has grown up in New Zealand. Right? So she has a South Asian background, but she grew up in New Zealand, so she also knows the way of life there. So when she started having discussions, so it's very funny. So Australians speak in a very different sort of English. They have their own words, and they use mate a lot. And this lady, who comes from a very conservative sort of a setup in Japan, she was not very professional. She had moved because her husband had moved, and she had to. And she had to take care of her children, and it's difficult to be in a new country where you have 3-4 children, you have to sort of. So, and she was not comfortable with a man coming in. And so this man very happily would come in every morning, and he would high-five that lady saying, hey mate, how's your day going? And she's completely traumatized. So, see, this can also happen in a mediation room. What to do to avoid such situations? Be strict mediators and tell them you cannot carry your smartphone inside the mediation room. Right. So, anyways, coming back to the story. So this lady finds it very intimidating when her boss comes up every morning and he gives her a high five saying, hey baby, how's your day? And she's like, what is going on? Why does he want to touch me? Whereas he has zero intention of any sorts. And to point that, so if you have ever visited that side of the land, Fridays, so the weekends start from Friday midday and it is till Sunday. Fridays in every office there's a party, right? And in party people drink. It's a very common thing there. If you don't want to drink, you can say no, I'm not comfortable or however. But this lady, she could never refuse because for her, boss is a senior male member who is asking her to do something and she cannot say no. So she had to consume that alcohol, and obviously because she's not used to or she doesn't like whatever, when she would go back home, she will have dispute with her husband. So this kept on happening for a long time, and she never had the courage to stand up and say, see, I don't want to. And trust me, the man would have taken zero offense because he didn't even realize that all this was happening in the background. So this thing ended up piling day after day to a point where she said, I will not work here anymore. Anyways, that issue got resolved, things were sorted, and what this lady, she did, it's a very nice gesture. She made sure that the boss learns more about Japanese culture, and she made sure that this friend of ours, she learns more about the culture there. You know, how Australians speak and how they usually are, and that helped resolve the thing. So come to think of it, this is a cross-cultural mediation that is happening, right? People might not want to mean that, but that's how it ends up being. So this is also one of the places where mediation is emerging a lot, right? Now, okay, so just to make sure that you don't doze off, do you have any idea about any sort of platform where online mediation is happening or where it can happen? Yes, somebody there.
I was actually part of an online mediation
Right.
with the SIMC,
Okay.
where I was part of a dispute and my aunt died in a hospital in Singapore.
Okay.
He had the entire online mediation done via Zoom, and he spoke about the rooms.
Right.
We were in separate rooms. The
Right.
mediator was in a separate room, and he would bounce between rooms and he would negotiate with the doctor and us
Right.
as to what we have. So I think SIMC has been doing it regularly during COVID. I'm not sure of the situation
Yes,
now.
definitely. Singapore International Mediation Center, it's one of the worshipping places for mediation people, I have to say. That's a very good example. Thank you. How did you feel in that online mediation process?
It was good, but I don't want to stall everyone, but it's just we have to file a case first to bring them to the table. I just feel it's usually done by the court route, where the court ordered us, gave us an order to enter the mediation.
Right.
And only after that we were assigned to SIMC and we negotiated within 2-3 months. We came to a resolution, 2 sessions, and then we're back to the court to enforce the award that we agreed on.
And also in India. So, if somebody doesn't follow the court rules, they have this entire system where they will lock people to have tickets. Say you have a fine of 2,000 rupees, taka, right? And you're not paying that. So instead of having police to come over to you or, again dragging you back to the court and all of it, what they have done, their online ticketing system is completely underlocked. So till you pay that punishment money, you will never be able to buy tickets for yourself. Imagine the plight. So it's just it's a different world, and China has been doing it for a long while now. So we really need to gear up. And when we say ODR is the future, it is the present. Reality of the world is ODR is the present. And future is going to be AI, where robots will be mediators. And let me tell you why. because they will never have any sort of biasness towards anyone, right? And they would be good listeners. And so to ensure that doesn't happen, we humans need to get up. No, jokes apart. AI will always help in assisted mediation, and that's what it has been doing. There are a couple of companies who are using assisted AI to help with mediation globally. This international negotiations that actually happens in United Nations, where there are loads of data which has to be analyzed, and multiple people that needs to be considered. If they do not analyze data and if they just go by the whims and fancies of a few people, it's going to be difficult. Okay, we will have this chit chat a bit later. I'll end the session very soon. If you have anything to share, please share it with everyone. It's very difficult after lunch, I completely agree. একদম
আমি যা বুঝেছি যে অ্যাডভোকেসিরও দরকার নাই, কোর্টেরও দরকার নেই, সব অক্ষর দিয়ে
না, একদমই না, বিকজ সবসময় একটা জিনিস মনে রাখতে হবে, we always tend to think যে machines will take our place. কম্পিউটার এসছে তো অনেক বছর হয়েছে, মানুষ কি চলে গেছে? একদমই না,
মানুষই তো মনে রাখছে যে কম্পিউটারে কোথায় কি রাখছে।
একদমই তাই। Machines can never function, sorry? কমে গেছে, সেটা ঠিক। হয়তো আমাদের স্কিল সেট অন্যভাবে করতে হবে। Probably the language we would need to learn is not Bangla, Hindi or English. We need to learn coding, right? Maybe the way it is happening will come to think of it. Shakespeare in English কি আর আমরা বলি না, কিন্তু আমরা তাও সেটা পড়ি, right? So maybe it's going to evolve. And একটা জিনিস যদি আমরা ভেবে দেখি, আমাদের সেই ব্যাবিলনিয়ান ওই মানে পাথরের উপরে আঁকা থেকে we have come to a place where it is happening virtually. So that's the growth, that's the landscape, and it will keep happening. Alibaba, if you have heard about that particular platform, it's a e-commerce platform. PayPal, যদি আপনারা কেউ ইউজ করে থাকেন for any international payments, you have to use PayPal. So if there's a dispute, say you paid somebody something and that payment never got through, or somebody claims that never got through, all your bank accounts will be frozen till that dispute is resolved. And who resolves that dispute? PayPal. How does PayPal help resolve that dispute? It basically uses blockchain tech. Well, blockchain basically, okay, let me just simplify it. It sees all the history of your use and it sees a trend. আমি একটা খুব সহজ এক্সাম্পল দিচ্ছি। আমি ভোডাফোন ইন্ডিয়া ইউজ করি, ফোনের নেটওয়ার্ক, আর আমার পোস্টপেড বিল, ঠিক আছে? আমি কোনো মাসে যেই ডেটে পে করতে হয় সেই ডেটে পে করি না, প্রতি মাসে আমি 10-15 দিন পর করি। আমি লাস্ট 1 বছর ধরে দেখছি আমাকে ভোডাফোন রিমাইন্ডার যেই দিন ডিউ থাকে সেই দিন দেয় না, 15 দিন পরে দেয়। একদম কিভাবে সে সেটা দেয়? কারণ সে বুঝে গেছে এই ইউজার কোনোদিনও ওই দিনে দেয় না, তাই জন্য নিজের এনার্জি নষ্ট করে লাভ নেই। যেই দিন দেবে তার আগে পিছনে আমি তাকে এই রিমাইন্ডারটা দেব। সো ইট হেল্পস মি বিকজ আই এম নট ইরিটেটেড কি 50 বার খালি বিল পে করো আসছে, রাইট? And the company is also benefited.
এক্সট্রা মেসেজ দিতে হচ্ছে না।
Exactly. So don't think ever, do not think or presume that machines, AI is your enemy or is going to take your place. No, never. Never. গাড়ি হয়ে গেছে বলে কি আমরা হাঁটা বন্ধ করে দিয়েছি না? মানুষের কি পাওয়া মানে ওয়েস্ট হয়ে গেছে না? It just helps. The requirement, the need of the hour is to move with it. Right? Okay. Enough on technology. We'll go back to mediation. So now, where will this online mediation or where will this future of mediation come into picture? It will most probably be the best suited for cross-cultural mediation, where you have language barrier. Right? আমি বাংলাতে বলতে পারছি, ধরুন আপনারা শুধু ইংলিশ বোঝেন আর আমি ইংলিশ বলতে পারি না, then how do we communicate? Only if we have a translator. So let's say we are on an online platform, আমি জুমে আপনাদেরকে এই প্রেজেন্টেশনটা দেখাচ্ছি, যেখানে আমি যেটা বলছি জুম অটোমেটিক্যালি ওটাকে গুগল ট্রান্সলেটর যেরকম হয় সেরকম ট্রান্সলেট করে আপনাদের শুনিয়ে দিচ্ছে। Likewise, whatever you are saying or whatever your questions are comes back to me through the translator. Instead of thinking how to resolve, what to. So anyways, coming back to the point, so this cross-cultural collaborations will be of huge help. And I mean, abaro reiterate korchi, we are becoming global citizens, whether we accept that enough or not. If you look about yourself, apni jodi nijeke dekhen matha theke pao obdi, probably there are 10 things which we use which are not from our country. So it's coming. And it has got us in such a loop where we don't even realize that it's a foreign brand and we are using it. There are fruits, আমি কোনোদিনও এটা দেখিনি, একটা dragon fruit বলে একটা fruit আসে, it's from Thailand. I had never seen it in entire of my childhood and now it's there everywhere. Right? So we are becoming one community whether we accept it or not. So that is where the future lies, right? So I think for cross-cultural collaborations, online mediation would be a great fit. Then redefining accessibility and connectivity, as our friend there, he pointed out about this case, his personal case on SIMC. Of course, if you are in two different lands, flying to one place, finding out a common time, it's a very difficult thing, right? So if we have online platforms which help us, it's just a boon in disguise. Well, of course, when we are all using Facebook, Instagram and LinkedIn, we cannot just say that, okay, for everything else we want online platforms, but for things which are important, we can only do it in a set of fixed area or in one particular room. That's not fair, right? So, obviously, that's going to come. Now, the points which I think why online mediation will be better, it's because of its accessibility. It's going to be accessible super easy. After COVID, there are no two doubts in my head that accessibility will ever be a question. People used to say, how will people have network? How will they have laptop? This used to be questions before COVID. After COVID, I don't think those questions stand anymore. Cost, effectiveness, of course. Of course. If you are traveling somewhere, you're not going to be staying on streets. So you're going to stay there somewhere, you're going to eat, probably you will end up shopping. So there's a huge cost which is involved, which gets completely taken care of in online setup and global reach. I am, of course, we don't have anybody from pure IT background. My brother, he's working in this IT company called EXL. It's a consultancy which is based out of US. Every day at 6 p.m. he has this meeting. His clients are situated in Ireland, his manager is in Canada, and his company VP is in US. And that's how the work is happening, right? So that's what we need in our legal setup as well. So a couple of examples as to where we can understand that these would be applicable is an international business dispute. As I said, let's say my client has some problems with the work my brother is submitting, so all can be on one Zoom call or all can help resolve it and, such global business reach. Then family conflict on different continents. Let's say I have an uncle who stays in Canada and he's having a hard time letting go of the land to my father, so that can be resolved as well. And of course, workplace conflict. I gave an example about this about the lady and my boss. So that's there. And the rise of AI. So accept it or not, AI is already here. It's going to keep rising. It's going to be there. Better make use of it and better make friends with it. So what are the different potentials of AI? Number one is automated case assessment. Even before AI, WIPO, which is the World Intellectual Property Organization, WIPO, which is the Organization for Intellectual Property, they already have this entire setup where the moment somebody files for an IPR right, say a patent or a copyright, so it goes through its own format and it sees if there's any dispute before approving. If a dispute arises, they have this entire platform where people can file their case, they can, submit their arguments, explanation, whatever, and then it gets resolved, and it all happens online. Then communication enhancement. Natural language processing algorithms can aid in analyzing communication patterns, as I said. For example, as I was talking about this Haryanvi lady, say I am that Haryanvi lady and I speak very, very loudly. So maybe machine can help sort of modulate and reduce my volume. Have you ever seen this when you're watching match? Whenever there is ad, the volume always goes up. Whenever there is any commercial, the volume will automatically go up and you are struggling to find the remote where it is. Right? So just something like that, okay? Then predictive analytics for settlements. So basically, if you have certain claims, for example, I want to claim the land that is right there. And I am saying I'll pay only 25 lakh Indian rupees for that land. So before making that claim, I need to have data. I need to have that entire background. This is probably a 2 crore land that I'm claiming for 25 lakhs. It's never going to come to me. I'm just giving a very random example, okay? So analytics, data like that, whether it is really going to work out, whether the implementation is going to be in your favor, how to process this entire thing, you need data. And we are in the world of data right now, okay? So if we have AI who helps us manage that data, it's always a big thumbs up. And document analysis and management, I think this has become a very common legal tech scenario where you have multiple online platforms where you can just submit a contract and you read the terms of the contract and give it to you, and there are multiple platforms like that. So it's just getting better with AI, right? These are two platforms. These are two companies, eQuibly and Modria. I have worked with Modria myself. We tried to create this online platform to help resolve e-commerce disputes. I was then teaching in Bangalore, and so we used to call that ODR center. And in that place, we were trying to develop this platform where if you have a dispute against, say, Amazon or any other e-commerce platform, say you bought a sandal for 500 rupees and the sandal is defective and they're not paying it back and there's something going around. So you can lodge that complaint on our platform. We will approach the Amazon headquarters and we will request them to mediate, and that mediation can happen over that online platform. There, Modria was helping us in the technical end of it. So Modria, these are the two examples of platforms which are already running and there. Modria is a US company, but it's starting to or trying to have branches in South Asia as well. Well, case studies, I think there are multiple case studies about using of AI and ODR at this current point of time. We have already discussed a couple, so these are just a few more examples. If you want to take a picture and read it later, you can go ahead and do it. I won't delve too much into it. Okay. So, as I said and assured, augmenting, not replacing human expertise. AI, machines, whatever you call, can never take over humans. They can only aid, right? So the collaborative role of AI and human mediators is extremely important. AI's ability to analyze large data sheets and identify patterns is a big thumbs up. And it's the importance of human empathy. When I said, if we have a robot as a mediator who is going to have zero bias, but at the same time, imagine talking to a robot. When you are sad or lonely, do you ever use any chat platforms which are there. There are a lot of chat platforms, right? But you always end up calling your friend or, whoever it is your loved and dear ones, and you cry and cry. Even if they are very irritated, they're like, please stop doing this, don't call me anymore, I'm not interested in your sadness anymore. But you still do that because we like to have people who are listening to us with human empathy, right? So that robots can never take. AI in mediation holds the promise of revolutionizing the way conflicts are resolved. So, it's just going to change the entire game. Well, that's that for me. Thank you. I hope it was a decent session. And thank you for not sleeping. Because history right after lunch is hats off to you guys, I would have dozed off. But if you have any doubts, you want to discuss anything, as Goswami sir mentioned, you can probably give it in writing. I think there is a format there. If you want to come and talk to me, feel free to do that. Thank you so much. Have a great rest of the training session. I would say learn mediation. Try to implement it. It's a beautiful, beautiful process. It's a really beautiful process. And if we really ensure that it's being practiced and implemented, it will really go a long way for us and our country. Thank you so much.